This case, I am for the respondent. Respondent passed away long since.
Counsel appearing to the respondent states that the respondent is expired long ago. There's no purpose in keeping the present petition pending. It is disposed of.
Pardon to mention, Lord, item number 1 you will receive.
Whom are you for, madam?
I'm for the petitioner you will receive.
For the Commissioner of Income Tax?
No, Lord. It's item number 1.
You're in the wrong list, I think, madam. We are now on the weekly daily list.
Sorry, my Lord.
Weekly list, old matter, item number 2, MJC 88 of 1997.
Well, it's probably it's an old matter. It has been there's been a lapse, non-filing of requisite.
Yeah.
So
it appears that over all these years, the requisites have not been filed for even service of notice on the respondent. The petition is accordingly dismissed for non-prosecution.
any other cause of action for I can
No, 97.
Malo.
Weekly list, old matter, item number 3.
None appears dismissed for non-prosecution.
Weekly list, item number 4.
None appears. All of this dismissed for non-prosecution.
Weekly list, item number 5.
None appears dismissed for non-prosecution.
Weekly list, item number 6.
Since I am appearing for State Finance Corporation, Lordship, despite all efforts, but has not filed the requisites.
Right. None appears dismissed for non-prosecution.
Weekly list, item number 7.
None appears dismissed for non-prosecution.
Weekly list, item number 8.
None appears.
May I please?
What is the tax effect here, sir? Must be some few hundred rupees.
Case of refund
Of how much?
about 50,000 for 3 years, about 50,000.
I think so. Given the insignificant amount of refund, the court does not consider it necessary to continue to entertain the present petition, leaving the question of law open for decisions in another case. The revision petition is disposed of.
Weekly list, item number 9.
None appears dismissed from non-prosecution.
Weekly list, item number 10.
So item number 10, mirrors, I am appearing. Your Lordship have admitted this question, mirrors, on 23/2/2004, mirrors.
Right.
Only one question, and that is covered by your Lordship judgment, mirrors.
All right.
Only question is, mirrors, whether the first point tax paid goods, mirrors, which I have dealt in,
Yes.
and tax is paid by the first seller, can the subsequent seller at all be liable for suppression? That is the question involved, mirrors.
Right.
Admitted the, and your Lordship have decided in the case of STREB number 20 of 2007, had judgment dated 7/9/2021.
Taken that STREB
STREB 20 of 2007, my lords.
and date is
Date is 7/9/21. And question I am confining to only question number A. All other questions were not pressed. Only question number A.
the only question that is pressed for consideration. Reads is under.
Findings of the tribunal, page 29/30.
Right. 1 minute.
Page 11 is the question of law.
Page 11.
My lord.
My lord.
I believe my lord senior is only pressing the first question of law.
First question, only A. Capital A,
Whether
my
the
lord.
facts and circumstances the case, purchase of fertilizer on which first point sales tax has been paid and as such exempted in the hands of the petitioner, does at all lead to any evasion leading to enhancement of turnover?
My lord.
Question mark, paragraph. In view of the judgment of this court, dated so and so, in STREB so and so, the above question is answered in favor of the SSC and against the department. The revision petition is accordingly disposed of.
Mirrors, that Lordship's judgment takes care of, your Lordship refer to paragraph issue number 2, paragraph 26 and 27 and 28.
In view of
26,
the-
27, 28. my lord.
in view of the decision of this court, in view of the decision and in particular paras 26 to 28. There.
Fine. Okay.
All right.
Weekly list item number 11.
On behalf of Mr. Lal, your lordship, no instructions.
No instructions disposed of.
Weekly list item number 12.
None appears dismissed now.
Weekly list item number 13.
May I please, Your Lordship? So, Lordship, this is a matter relating to assessment for the year 1985, wherein the assessee present here before this Lordship is the Orissa Forest Development Corporation, which is an agent of the government of Orissa. And as per the Forest Act, the agent used to pay royalty to the state forest department and collect the forest produce and sells it before the market. And here in this case, the matter is the sale of sal seeds for the year 1985, wherein during the sale, the forest department pressurized the present petitioner to give declaration for or else pay sales tax against the royalty, to which this petitioner before this honorable court opposed the same and replied to the forest department that
Royalty is not a sale. Royalty is not sale price.
Yes, yes, your lordship.
My lord, here, in fact, the dealer has admitted it to be a sale and has furnished Form 34.
Doesn't mean any. This is not an admission. Is it
Sir,
actually a sale, please?
My lord,
Payment of royalty, is it a sale? How can it be a sale?
here, my lord, there is a division bench of our Honorable High Court, which has held it to be a sale. There also the dealer has admitted it to be a sale. Then the question arises whether he is entitled to get the benefit of Section 5 to capital A. There the Honorable Court has held that in favor of the department, that since the dealer has admitted it to be a sale and violated the declaration by making interstate sale, he has at the time of purchase, my lord, he has made a declaration that I am purchasing it to sell it inside the state. That declaration he has furnished. Thereafter he has made interstate sale. So the question is whether it amounts to a violation of that undertaking or not. There the Honorable High Court has held it to be a violation and that to be a sale, my lord. Here is the judgment, my lord.
Which year? Which year? Okay.
In fact, prior to taking your lordship to the decision, may I take your lordship to the impugned or page 15, my lord, the assessment order.
No, but here it is the Orissa Forest Development Corporation, please.
Yes, my lord. There also a person has been appointed by the state. Here also OFDC has been appointed by the state. My lord, may first turn to the assessment order. That starts at page 14. My lord, may turn to page 15.
No, here the assessee is the OFDC itself.
Yes, my lord. OFDC claims to have been engaged by the state to collect this sal seeds, my lord.
No, royalty.
My lord, he collects sal seeds from the collectors and pays royalty to the state, my lord. There in that judgment also, that dealer has been engaged by the state to collect sal seeds from the collectors and pay royalty on the basis of the total amount that is purchased, total quantity of purchase, my lord.
No, if the Orissa Forest Development Corporation is not a separate entity from the state for this purpose, how can it be made to pay sales tax? I'm wondering.
In fact, it has been engaged by the state. It's a government corporation, my lord, no doubt.
Yes.
But he has been engaged by the state.
In fact, if your lordship appreciates, I would take your lordship to annexure wherein it is clearly mentioned about the appointment of the petitioner as the agent of the state and Just a minute, Your Lordship. It is under Annexure 1. If Your Lordship appreciates page number 8, wherein the notifications dated 10th May 1985, different divisions of the petitioner's corporation has been appointed as an agent to collect the forest produce. And apart from that, as my learned friend produced the judgment of this Honorable High Court.
Page 8 is a letter dated 27 January 1986, correct?
Page 8.
Page 8 is a letter dated 27 January 1986. Page 6 is a notification dated 10th May 1985. Just show him the paper.
Actually, I may be having some page numbers. It is Annexure 1 is the 10th May. Okay, beg your pardon, Your Lordship, the page numbers have changed in my copy. It is Annexure, same Annexure 1. Annexure 1 is the notification wherein the state government has appointed the petitioner's corporation as an agent to collect the forest produce on payment of royalty. And under Annexure 2, the rates of royalty has been fixed by the state government.
Itself. Correct.
And if Your Lordship permits, I may just place the last part of the judgment produced by my learned friend. The judgment, it is in paragraph 3, wherein this honorable court has expressed its own doubts. I may be permitted to place the paragraph 3.
That's right.
We have our own doubts if collection of mahua flower.
Correct.
Pardon?
Correct. On purchase of would, on payment of royalty would amount to purchase. That's what I'm asking. How can it
The
be
next
purchase?
sentence, my lord. In this case, however, the dealer has not questioned whether
Here he is very much questioning, sir. He has come before the court. There he didn't even question. Here the dealer is coming before the court and saying, how can I was just appointed as a in fact, OFDC is registered under the Sales Tax Act? Is OFDC registered as a dealer under the Sales Tax Act? I doubt very much.
I'm just producing judgment of this Honorable Apex Court, 1998.
But anyway, this payment of royalty cannot amount to collection of royalty on behalf of the state cannot amount to sales by the.
In fact, my lord, that question is still persisting. It is before the Honorable Apex Court. Whether the sales tax or VAT can be levied on royalty or not. That question is still before the Honorable Apex Court.
Yeah, but anyway, here this is not a sale transaction at all.
Here, my lord, says he is the agent, so transfer from the agent to that on that light, my lord. But this question, whether it amounts to or tax can be levied on royalty or not, this is pending before the Honorable Apex Court.
Let it be.
But here, OFDC being an agent, my lord may.
In the year 1985, Honorable Apex Court has clarified in a judgment of State of Orissa versus Titagarh Paper Mills, which is also thereafter in the judgment produced before your lordship right now. That is the Bhadrachalam Paper Boards versus State of Andhra Pradesh. Herein also it has been clarified that there will be no sales tax on royalty.
Which paragraph is that?
And since royalty doesn't amount,
where are you reading, sir?
Pardon, your lordship.
Which paragraph of the judgment that you have handed over says no sales tax on royalty? Which paragraph?
Yes, your lordship. Paragraph 8, we have seen the appellant sought declaration that tax demanded and collected on transactions in question for the period 1978-79
doesn't say that sales tax is not leviable on royalties.
Not, it was, it has said that it is not accessible to tax and the refund was denied.
That's
So
different.
that is my contention.
The present revision petition, while admitting the present revision petition by the Orissa Forest Development Corporation Limited (bracket OFDC) on 14th September 2006, this court framed the following question for consideration. Open quotation: whether the tribunal was justified in concluding that royalty paid by the corporation (bracket petitioner) has become a purchase price and it is the sale price in the hand of the concerned DFOs. Unquote. Paragraph. From the documents placed on record, and in particular the notification dated 10th May 1985, issued by the Forest, Fisheries and AH Department of the Government of Orissa, it is seen that the OFDC was merely appointed as an agent on behalf of the state for purchase of and trade in sal seeds for the year 1985. Open quotation: on their behalf in respect of units as notified by the government of Orissa, ... unquote. The relationship of the state to the OFDC was that of principal and agent. We'll stop. The rate at which royalty had to be collected was also fixed from time to time only by the government of Orissa, as is evident from the notification dated 24th November 1987, bracket annexed 2 by A. Consequently, the court fails to appreciate how the collection of royalty by OFDC could be characterized as a sale of the sal seeds by OFDC. A sale price as the price for sale of sal seeds by OFDC. Full stop. Paragraph. Counsel for the department sought to place reliance on the decision in State of Orissa versus Iqbal Brothers, 1990-79 STC 337, to contend that sales tax in such instances was leviable on the royalty paid to the Forest Department, which would be the purchase price in the hands of the dealer for the purposes of levy of purchase tax under Section 3 capital B of the Orissa Sales Tax Act 1947. Post of paragraph. A perusal of the said judgment shows that tax was sought to be levied on the royalty amount paid to the dealer for the mahua flower on the price paid to the dealer for the mahua flower, which in turn had been collected by him from the Forest Department on payment of the royalty amount. Full stop. There, no contention was raised that the state government itself was undertaking any sales. Full stop. Significantly, the court commented in para 3 of the judgment, open quotation: we have our own doubts if collection of mahua flower on payment of royalty would amount to purchase of such goods, unquote. However, the court proceeded to answer the question before it in favor of the department only because, open quotation, the dealer is not questioned whether the transaction amounts to purchase, unquote. Paragraph. In the present case, however, OFDC is certainly questioning the treatment of royalty as single quote sale price and making it amenable to sales tax. Full stop. OFTC cannot be characterized as a single quotes dealer unquote for the purposes of the transaction question, that is supply of sal seeds after paying on payment of royalty. Full stop. Consequently, the court is not convinced with the submission of the department that the transaction question is a sale and that the royalty paid to the state should be characterized as single quote sale price unquote on which tax is to be paid. Paragraph. The question framed is accordingly answered in favor of the SSC and against the department by holding that the tribunal was not justified in concluding that the royalty paid by OFDC to the state is its purchase price and further and that it is the sale price in the hands of the concerned DFOs. Full stop. The revision is accordingly disposed of.
Quickly list item number 14.
May please, Lord. Dear my lord, the question of law is that whether the collection of meter rent by the distribution licensee, the gridco here, from the consumers that amounts to sale.
What are they collecting from the consumer?
Meter rent. They install a meter at the consumer.
Meter rent.
Meter rent per month they collect. That we contend as a right to transfer of right to use the goods.
How is it a sale? But
sale definition as per the Sales Tax Act includes a transfer of right to use goods. That my lord, note Article 329A, that definition is also there.
No, but that may be a service tax. It's not a sale on rent. Earlier also, you were collecting service tax on rents, not sales tax.
My lord, kindly see the definition of sale in the Sales Tax Act.
Yes.
It includes transfer of right to use of the goods.
All right.
So here, the distribution licensee transfers the meter for use by the consumers.
Where is the case law for this? Which is a judgment you're relying on?
But my lord knows that recent decision of that BSNL versus Union of India, whether the telephone connection that amounts to whether sales tax can be leviable or not. There, the Honorable Apex Court, I'm just reading one paragraph, my lord. There may be a transfer of right to use goods as defined in answer to the previous question by giving a telephone connection, my lord. Here, my lord, the meter is being installed by the distribution licensee with the consumer, and he collects a rent per month, my lord. So, in our humble submission, my lord,
what is it? You've just read some one line and you started arguing. What is said in the judgment, please?
Beg pardon, I couldn't give the citation, my lord.
No, but even the judgment which you're reading one line and then arguing. What does that judgment say?
My lord.
What does the judgment hold?
Here the question was whether giving of a telephone connection to the consumers that amounts to sale or not.
And what did the court hold?
The final paragraph, we answered the questions formulated by us earlier in the following manner. Goods do not include electromagnetic waves or radio frequencies for the purpose of Article 366(29)(a)(d). The goods in telecommunication are limited to the handsets supplied by the service provider. As far as the SIM cards are concerned, the issue is left for determination by the assessing authorities. There may be a transfer of right to use goods as defined in answer to the previous question by giving a telephone connection. The nature of the transaction involved in providing the telephone connection may be a composite contract of service and sale. It is possible for the state to tax the sale element provided there is a discernible sale and only to the extent relatable to such sale.
Correct. So you don't have a mechanism to determine that. So you can't pick up the entire rent and say now pay sales tax on the rent. There's a service element there. So you go back to those line of decisions which say unless the statute itself spells out the mechanism.
The measure of tax, madam.
It will fail. The tax itself will fail. We'll end up taxing too much. What we call the machinery provision. It has to have the machinery provision.
Madam?
It has to have the machinery provision.
Yes.
That is how much of this transaction pertains to sale element, how much pertains to the service element.
Yes, madam. That is not there.
It's not there. You see, the short question that arises for determination in the present revision petition is whether the rent collected by the petitioner for installation by the dealer, that is Gridco, for installation of electricity meters will amount to a sale as defined under section 2 bracket G 2G of the Orissa Sales Tax Act 1947 bracket OST Act. Counsel for the department wants to argue that the definition of single quote sale as contained in section 2G
GIV.
4 bracket 4 is wide enough because it talks of single quotes transfer of the right to use any goods for any purpose for cash, deferred payment or other valuable consideration, unquote. According to him, the right to use the meter, electricity meter, is being transferred by Gridco to its customer for which it collects rent. And therefore, the rent so collected must be treated as the single quote sale price, unquote. Paragraph. Reliance is placed on the decision of the Supreme Court of India in
2006, volume 3, SEC, page 1. BSNL versus Union of India.
BSNL is Union of India. Stop. The relevant portion on which Reliance is placed reads as under.
Can I add one line, Your Lordship?
Yes.
Your Lordship, by perusing this judgment of Honorable Supreme Court in BSNL case, recently Your Lordship has set aside all the BSNL group cases to the assessing officer for to do appraise as per the judgment of the Honorable Supreme Court.
Yeah, that is different, sir. That is when BSNL was before the court.
Paragraph 92, Malik.
Your Lordship.
Just say A to A. In the present case, there is no machinery provision in the OST Act which enables the assessing officer to determine the sale element separately from the single quote service element in the transaction of renting out of electricity meters. In the absence of such a machinery provision, the collection of sales tax on the entire rent would obviously be unsustainable in law. Paragraph. Consequently, the question framed by this court by its order dated July 2015 is answered in favor of the SSC and against the department by holding that the meter rent collected by Gridco from its consumers is not liable to tax within the meaning of single quote sale under the OST Act. The revision petition is disposed.
Weekly list item number 15.
None appears dismissed.
Weekly list item number 16.
16, may I please, my lords?
Yes.
Question formulated in this case, my lords, your lordship will find at page 27. Page 27. There are so many questions formulated because I am confined to question number B and H, my lords. Small b and H, my lords. There's, your lordship got it. Page 26, question number small b, and question number 27, my lords, question number H at page 27. Now, precisely the question here what arises for Lordship Bills, that's tax realized at the check post bills. That's in course of transportation purportedly under Rule 94 of the Orissa sales tax rules. Allegedly for non-accompaniment of the documents along with the vehicle in course of transportation. Where the transporter, even though I will take your Lordship's attention relevant Rule 94 which says that the notice in statutory form 6B is to be issued to the owner of the goods. But here is a case where notice was given to the transporter and the manager appeared, he recorded the statement and he agreed to pay. That is how the tax was collected at the checkpoint. The very same transaction in the assessment was taken to be a case of suppression and enhancement made up to 20 lakhs bills. That is the point below. And this 20 lakhs enhancement is attributed out of this major source of giving rise to demand. And the second is question number H, whether the sales tax determined in respect of hosiery woolen garment is exigible to tax at the rate of 12% or under entry, under entry 103 of the taxable list or under entry 20. The Lordship may kindly read the rule, maybe read as entry. It's a print, typing mistake, my lord. Or entry 22 of the taxable list. My lord, entry 103 deals with woolen goods including woolen yarn. And my lord, entry 22 speaks of hosiery goods including ready-made garments. That's what I have done the assessing officer. That's one by one I am placing mirrors. First of all, let me place you for this question number H regarding these two competing entries. Your Lordship will find from the assessing officer's order what I deal in. That your Lordship will find at page 31. 31. The dealer is carrying on ready-made garments, hosiery goods, woolen goods, and sunglasses at a retail basis. Whereas what I deal in is ready-made garments, hosiery goods, and woolen goods. Whereas once a goods falls under hosiery goods, which is a specific entry, hosiery goods, I found from dictionary because I won't get a judgment. Dictionary says that the meaning of hosiery goods is stockings and socks and tights. So this is the meaning of hosiery. Unlike the outer garment like shirt, trousers, all that this is the precise meaning of hosiery goods. And merely because this is made out of wool, that cannot be covered under the other entry, which is and that is 12%, hosiery is 4%. So my humble submission is that when this is purchased and sold as hosiery goods, entry 22 is more attractive than the other entry, which is not specific. Rather, hosiery is a specific goods. It has its own identity. And it may be made of cotton, wool, or any other material, silk or whatever. But hosiery goods, once it is hosiery goods, it cannot be under any other entry. There is no dispute that I sell hosiery goods as well. So that is one . And the turnover is 1,92,000, tax impact is 15,000 somewhat out of the total demand. So this is one. And so for the first question, I am taking also the important question, first question. That is question number B. This matter I find is covered by one judgment of our High Court in the case of Binayak Stores case. What I have, if you also permit me, only two paragraphs I will place.
Yes.
Yes.
What is the citation? What is the citation?
Yes, ma'am. Citation is, my lord, this is 1992, 86 STC, page 423 Odisha. Vinayak Store versus sales tax officer and others.
Vinayak Stores versus sales tax officer.
Right. The paragraph 3 says, the manner of collection of tax at the check post and procedure to be adopted have been indicated in Rule 94 small a of the rules. If on inspection, the officer in charge of the check post finds that goods transported in a particular vehicle are not fully covered by a waybill in Form 32, or that the waybill is defective or incomplete, that there shall be evasion of tax in respect of the goods carried on in that vehicle. Notice shall be issued on the owner of the goods or any person in this behalf in Form 6B, giving him an opportunity to rectify defects or omissions, if any, or an option I could appear for physical hearing. I'm extremely sorry, my lord. I'm reading the next paragraph, paragraph 4. On the facts of this case, we find that there is dispute on the question whether there was voluntary payment of the tax by the drivers of the vehicle or there was collection of tax without following procedure prescribed by law. Be that as it may, in respect of the amount already collected, we direct that the same shall be taken into account while making assessment. The petitioner is entitled to adjust the amount paid against the admitted tax payable in terms of the third proviso to Rule 33 of the rule.
In your case, the transporters already paid tax under Rule 94.
Exactly, my lords.
So you want an adjustment of that when it comes
I want adjustment, and secondly, my lords, that cannot be again the basis for treating as suppression and making enhancement of 20 lakhs.
Right.
That is the point, my lords. If somebody has paid tax on the very consignment, which has later been after, that is not a point where I have goods in my business premises and I have sold. That is in the course of movement from outside the state at the border entry gate, goods are detected. And the peculiar case is that has come, the vehicle has come, again it is re-entered, people, because that is a vehicle carrying so many goods under a manifesto bills. So far as my goods is come.
How is the second question related to the first then? Whether it should be entry 22 or entry 103, how does that
No, that is these two are my different, totally different questions. These two are different issues altogether.
Okay.
Altogether different.
Or what are you selling here in this question B, which the transporter was paying tax? What was those goods? Those are also hosiery goods.
Those are mirrors. The ready-made garments mirrors. Shirts.
I see.
The dresses mirrors. Dresses. Okay. And I had purchased from Calcutta. Okay. And the goods are coming under documents, transporter. I have also annexed the document that consignment note, freight receipt, and that has also reflect the purchase bill number. And way bill was also there. Under Rule 94, the mandatory requirement way bill will also. The statutory way bill containing all details of the consignment, details of goods I carry, where it is going, from where it is coming. All these things are there. Despite of this, what the course available under law to the checkpost office, he has to issue a notice in Form 6B to the owner of the goods, pointing out that these are the defects you are required to remove. If I remove, it's all right. If I do not remove, then he may ask me to pay tax. If I do not pay tax, he may seize the goods, he may confiscate, and those are many ways are open to him to follow. In this case, what he has done, instead of giving me the opportunity, he issued notice to the transporter, manager appeared, he volunteered to pay tax because the transporter was carrying any other goods also of other owners' bills. So to avoid dispute, whatever, he has problems, he wanted to pay tax. And he paid tax bills. Now the question arises, if in respect of particular consignment, right or wrong, the transporter agreed to pay tax, even if without following the procedure mandated under Rule 94, can the assessee be at all again without being getting the advantage of getting adjustment in terms of enhanced judgment bills? Again, that would lead to suppression and 20 lakhs enhancement. That's the question, Miras. There cannot be double jeopardy on the same allegation.
All right. Yes, Mr. Sipadi.
As far as the question number B is concerned, my learned senior is citing a judgment, my lord. But as regards that other, in which entry it would fall, my lord. In fact, if your lordship would turn to the assessment order, page 2, 31, page 31, running page. In fact, the dealer was carrying on the business in ready-made garments, hosiery goods, and woolen goods. So he's dealing with both these goods. And if my lord would see third paragraph in that page 31, on examination of accounts, it is revealed that the dealer is paying tax at the rate of 4% on the sale of woolen garments. The entry says woolen goods, including woolen yarn and thread, but excluding mill-made fabrics and khadi woolen goods, is taxable at 12%. So, as regards hosiery goods, there is no dispute that you will be paying 4%. But as regards the woolen goods, my lord, it reveals from the account that he was paying 4%. The entry is quite categorical, my lord. Entry is woolen goods, including so and so, so and so.
Woolen goods, I don't have any quarrel bills. It is liable to be taxed at 12%, 12%. Now, what he says, because the hosiery goods are made of woolen, to the extent hosiery goods are made of woolen millets, wool millets, he says that this is woolen goods. Even if that is hosiery, otherwise. But because this is made, supposing mirrors, hosier goods made out of cotton, hosier goods made out of wool or made out of silk mirrors. Now, the stand of the revenue is the hosier goods is to tax at the rate of silk, at the rate of cotton, and at the rate of wool. My humble submission proposition for Lordship is that once it is hosier goods mirrors, the entry 22 attracts. It cannot be at a higher rate. And the difference is 8% mirrors. Hosier is 4% because the legislature has kept in mind hosier is the basic element of basic requirement of the people. They need it because of all those mirrors things in mind. Legislature has been soft in taxing those at a lower rate than the other goods which are luxury goods or that can be taxed at a higher rate. Hosier goods, legislature intends to tax at a lower rate.
Then, my learned senior would have to demonstrate, the dealer have to demonstrate that the woolen goods are made, the hosiery goods are made out of woolen, because the assessment order says that he has paid 4% in respect of woolen goods. That's what the assessment order says, madam.
Woolen goods per se, pure woolen goods, and hosiery goods which happen to be woolen.
Yes.
Yes, my lord. Then he has to demonstrate, the dealer has to demonstrate that.
Can that question go back to the STO?
This is, of course, 18 years after.
Or we leave that question open for decision some other case. That tax component can't be much.
That tax component, my lord.
We'll leave it open for some other case.
Yes, yes.
All right. They admit the following two questions are framed for consideration. From page 11. Page 26. Question B. Whether in the facts and circumstances of the case, there being realization of tax under Rule 94 of the OST or Orissa sales tax rules, bracket OST rules, from the transporter in respect of the consignment notes dated 22nd June 1994 at the Chakuliapada.
Chakshuliapada check it.
Chakshulipada.
Chakshuliapada check it.
Chakshuliapada check post. Whether it can again be taxed on the ground that it constituted suppression on the part of the petitioner. Question mark. Then the next question is whether the rate of sales tax in respect of sale of hosiery woolen garments is exigible to tax at the rate of 12% under 103 of the taxable list or under entry 22 of the taxable list. Question mark. Paragraph. The brief background facts as far as the above questions are concerned. Are that
but in this case, first appeal was allowed in my favor, and the first appeal authority has dealt this fact in Mirror's paragraph
page 36 onwards.
Page 36 on my
The petitioner is a dealer carrying on business in ready-made garments, hosiery, woolen goods, and
report number subpara 1 at the last line. Report number so and so by 9495. Yes. One vehicle there it starts.
and sunglasses, etc. For the period (1995-96). No, sorry, for the year 1994-95.
94 nahi, minor.
While goods were being plied, ready-made garments were being plied from Calcutta to Rourkela. Were intercepted by the sales tax vigilance wing of Baleshwar division at the Chakshuli-Pada checkpost. Full stop. The dealer's transport agent
Modern transport.
allegedly failed to produce the relevant documents, leading to the collection of tax at the checkpost in respect of 2 waybills in terms of Rule 94 of the OST rules. Paragraph. In the course of the assessment, the sales tax officer, bracket STO, in his order dated 15 November 1995, held that notwithstanding the payment of tax by the transporter, the transactions covered by the above 2 waybills should be considered to have been single quote suppressed unquote by the dealer, that is the petitioner, and on that basis the taxable turnover was enhanced
By 20 lakhs, page 34.
by almost rupees 20 lakhs, leading to a consequential enhanced demand of rupees 726,532.64. Paragraph. The above order, the assessing officer AO, was reversed by the first appellate authority, namely the Assistant Commissioner of Sales Taxes, Commercial Taxes, right? No, Assistant Commissioner of Sales Tax.
I'm so sorry, Milos. It is confirmed, Milos. I'm sorry, Milos.
Sorry?
Yes, my lord. It
It
was
is confirmed, Milos.
the assessment order is confirmed in the appeal.
Not reversed. But this was confirmed by the appellate authority, namely the Assistant Commissioner of Sales Tax, for the order dated 30th November 1996. For the further appeal by the dealer was dismissed by the Orissa Sales Tax Tribunal by its order dated 10th November 2003 in essay number 2419 of 1996-97. Paragraph. This court heard the submissions of Mr. Jagavant Sahul and senior counsel for the petitioner and Mr. S.S. Padi, learned standing counsel for the department. Full stop. Mr. Sahu referred to the decision of this court. Where is that, sir? Can you give this? In so and so is so and so, and contended that it was incumbent on the department to have given credit at the time of recomputation of the time of assessment to the tax already paid by the transporter at the check post in terms by the dealer. Stop. There is merit in the contention that the same transaction cannot be subject to sales tax twice over, one at the hands of the transporter and another at the hand of the dealer. Stop. In that view of the matter, the enhancement of the taxable turnover of the dealer, SSC dealer, in the manner it has been done by the STO in the assessment order dated 15 November 1995, cannot be sustained and is hereby deleted. The question framed by this court is answered in favor of the petitioner SSC and against the department. By holding that the realization of tax that the same transactions covered by the two consignment notes in question cannot be treated as suppression on the part of the dealer and cannot be taxed twice over. Paragraph. Turning now to the second question, it is seen that the amount involved is not substantial. Consequently, leaving the question open for decision in some other appropriate case, the court declines to answer it in the present revision petition.
Question number H, your lordship. Question number
Yes, H. I've asked him to take H only. The revision petition is disposed of.
Obliged, my lord.
Weekly list item number 17.
Here, my lord, division bench of a tribunal had disagreed with the decision of the full bench without any assigning any reasons and held that bandage cloth and gauze cloth are taxable item, my lord. Your lordship may turn to page 26 of the order of the tribunal.
Yes.
Para 3.1. We have gone through the decision of this tribunal awarded previously in the case of Banner Surgical Mangalabag, Cuttack and Messrs. Orissa State Bandage Weaver Cooperative Society, Bhubaneswar, but we differ in our opinion. We are inclined to observe that the bandage clothes and gauze clothes sold by the
Should have been referred to a larger bench.
The larger bench decision. Sorry, when?
No. You're saying this should have been referred to a larger bench if they were.
No, larger bench decision already was there, my lord. Annex of 5, my lord, page 29.
So they differed from that.
No, yes, they differ without assigning reason. This is a division bench. It's a larger bench is at page annex of 5, page 29.
No, my lord. That larger bench, the facts were completely different.
No, but here they're saying we differ
Because
in our opinion. Distinguishing is different from differing, right?
My lord, the language may be different, but that full bench judgment is here, my lord. My lord may kindly see. The language may be, yes, the language is not that.
No. Does the full bench hold that bandage cloth is drug and medicine?
For that dealer, my lord, for that dealer, unlike the present dealer.
No. How can it be changing from dealer to dealer? What
yes,
is
my
this?
lord. If that dealer is dealing with handloom goods, and here the dealer is only dealing, it's a, my lord, kindly see, here the dealer is, the dealer admits, my lord, may kindly, page 23, my lord, may kindly see.
Yes.
Let it go back.
My lord, yes.
It can go back. Because this is not the way to
Yes, my lord, the language, yes.
Hmm.
But my lord, the dealers are very different. Here the dealer is, my lord, is only is a manufacturer and seller of semi-bleached and unbleached bandage cloth, gauze cloth, rolled bandage, rolled gauze. There,
So all of this is medicine and drugs.
rolled medicine and drugs, my lord. That is what the department is saying. It will come under medicine and drugs. He is saying it will come under the.
What does the full bench say?
Rolled bandage, I have no dispute. I have paid tax on that.
The full,
There is no dispute. It's only with regard to bandage cloth.
my lord, the full
Gauze
bench.
cloth. And this is bandage cloth, gauze cloth has been decided by the full bench.
No, my lord. Full bench
Finding is
in
there.
the case of a dealer who was admittedly dealing with business of handloom cloth. In that case, he is the dealer. The full bench has answered the question, my lord.
No, but that same dealer is supplying that handloom cloth for bandage purpose, right?
Yes, but if the handloom cloth.
No,
is
here
used-
also I think bandage cloth here.
Bandage cloth, gauze
He's
cloth is
only-
not taxable, but rolled bandage are taxable and I have paid tax.
Roll bandages.
I have to pay tax. And all this gauze cloth and bandage cloth has been supplied to the government also. There is no other
gauze
private
cloth
sale.
and bandage cloth, these are, my lord, in my humble submission, that
No. When it is rolled up as bandage, he pays it as the basis of drugs and medicines.
Yes.
When he simply supplies it as cloth, he says, don't treat it as medicine.
my lord, for any other non-medicinal use, yes, it cannot be come under this category. But here, my lord, the fact would demonstrate. In fact, the dealer has himself admitted to have only it using for medicinal purposes. That's the finding of the tribunal, my lord. The language is
There's no
different.
such
They have
finding
differed,
No,
but
you are supplying this cloth to the government for what?
Government hospital, no
Hospital,
dispute.
my lord, yes.
But these are not taxable. What I'm saying, these are the full bench has said is not taxable.
No, because there the dealer was otherwise handling handloom cloth, dealing in handloom cloth. Whereas you're not otherwise dealing in handloom cloth. The only thing you're doing is supplying to either hospitals or selling roll bandage.
Yes, my lord. What I'm saying, the weavers also have supplied, and the venous surgical. There are another division bench, my lord. Venous surgical, coordinate bench decision. Venous surgical, 2 decisions were there. There is no such finding that weavers were not supplying to the government. They take it. There's no finding. He's saying,
No. Venous surgicals also they taxed it as cloth. I mean, what was held in venous surgical?
Venous surgical also bandage cloth and gauze cloth. There is a division bench decision. They say it's not taxable
as medicine.
Not taxable as medicine. Yes, it is a tax-free item under power looms.
No,
and
that venous surgical was cited before this bench.
Yes, they have taken note of it in this order.
Where?
Para 3.1, page 26. We have gone through the decision of this tribunal awarded previously in case of Mrs. Venous Surgical, Mangalabad, Cuttack, and Orissa State Bandage Weaver Cooperative. Orissa State Bandage Cooperative waiver is by a full bench, Annex 5. And so Venous Surgical is by a division bench of the tribunal.
I think that should be a proper discussion. Let it go back. You say this revision application arises from an order dated. This revision application by the SSC dealer arises from an order dated 28th February 2004 passed by the Orissa State Tax Tribunal, Tribunal. Dismissing the petitioners, allowing the department's appeal, bring essay numbers 1629 and 1630 of 1997-98. Paragraph.
All other points I may be given liberty to raise, my lord, because here also the assessment was earlier completed and thereafter reopened without without any reason to believe and as per the records.
No, it's question not been framed yet.
In A, at page 5, my lord.
Yes, page 5. In fact, the first, I believe only the first question apply my understanding is page.
This is second point B, and so also para M and N, page 8.
No question has yet been formally framed.
Yes, ma'am.
No, by an order of this court, no question has been framed.
Yes.
Yes, meaning what?
No, my lord.
No order has been framed. No question of law has yet been framed.
The following questions are framed for consideration. Some IA you filed for some additional question. What is that?
That has been allowed. Their consolidated petition have been filed. That is para M and N.
Para?
M and N, page 8.
These two questions, sir. No, but this is all about reason to believe, M and N. Whereas what you're arguing about bandage cloth and all is very
That is subsequently amended in 99. By way
sir,
of
the main
notification, they have
question that
taken-
you're
they have
urging is whether it can be treated as gauze cloth.
Yes.
They have made it
Whether
taxable.
Which is that? Where is that question?
my lord, it's page 59A, paragraph 9A. In fact, 9 starts the following substantial question of law
The
is
following
involved in
question
this.
of law is framed for consideration. Whether bandage or gauze cloth are taxable as single course drugs and medicines with reference to entry 37 of list C of the Orissa Sales Tax Act, or is it exempt from sales tax as single course handloom fabrics with reference to entry 16 of list A of the tax-free goods under the Orissa Sales Tax Rate Chart? Question mark.
There is a notification, it has come in 99, my lord. Where second phase, cotton gauze and bandage gauze of all varieties, they made it taxable only after 99. So this period is 92, 93, 93, 94. Period.
Our period.
It cannot have a retrospective operation.
It cannot have, no?
Yes.
You see, the period in the question is 92-93. Paragraph. The court finds from the impugned order of the tribunal that the petitioner had sought to place reliance on two decisions of on a decision of this court, or is it tribunal? On the decision of a division bench, on the decision of the two-judge bench of the tribunal in Venus Surgicals, Mangalabag, Cuttack versus sales tax officer. What is the citation there, sir? Any citation? The tribunal's decision in Venus Surgical.
Venus Surgical case. This is why the tribunal.
As well as the decision of the full bench of the tribunal in Messrs. Orissa State Bandage Weaver Cooperative Society, Bhubaneswar versus STO. Paragraph.
I'm sorry, Venus Surgical is by a single bench.
In para 3.1,
there is another division
of the
bench.
impugned order of the tribunal.
That's
It
by
is simply
Venus
stated
Surgical
that
is by division bench. Sorry.
the tribunal was differing in its opinion, and it was concluded that bandage cloth and
Vijay
gauze cloth
Surgical
sold by
division.
the dealer in the present case, open quotation, do not come under the broad category of drug and medicine subject to levy of tax under the OST Act. Here they have held it does not come.
Do come, my lord, not is
Do come, yeah.
Do come.
Paragraph. You see, it is actually decision in State of Orissa versus Venus Surgical, Mangalabag, Cuttack. Bracket decision dated 25th October 1978 in essay number 176 of 1978-79, and the full bench decision. Where is that Weavers Cooperative? What happened that?
Full bench decision is page 29, Annex 5. In fact, the second paragraph starts, the respondent
State of
society
Orissa
carries on the
versus-
business of.
Finding is page 33, para
Full bench
E.
in State of Orissa versus Orissa State Handloom Weavers Cooperative Society, bracket, decision dated 27 November 1989. In essay number 366-69 of 1985-87.
86-87.
Sorry. Correct. The court is of the view that a two-judge bench of the tribunal could not simply, single quotes, differ, unquote, from the decision of the full bench. And if it was going to doubt the correctness of that decision, it had to refer the matter to a larger bench. No, and it could differ only from an opinion of a coordinate bench and not from that of a full bench, since a full bench decision would be single quotes binding, unquote, on it. Mr. Padi then offered that what the tribunal intended to do was to single quotes distinguish, unquote, the decision of the full bench and not single quotes differ, unquote, from it, full stop. Considering the language used in the impugned order of the tribunal, the court considers it appropriate to set aside the impugned order of the tribunal and remand the appeal filed by the state to the tribunal, being STA numbers 1629 and 1630 of 1997-98 for a fresh decision in accordance with law. Full stop. This time, the tribunal will discuss in detail the decision of the coordinate bench in Messrs. Venus Surgical Supra and the full bench in Messrs. Orissa State Handloom Weavers Cooperative Society Limited, bracket Supra. The question accordingly is left unanswered, awaiting the decision first of the tribunal in the matter. The revision petition is disposed of. The aforementioned essay numbers, whatever filed by the state will now be listed before the tribunal on 18th April 2022 for directions.
Both the cases, my lord.
Collected is for another year.
Just put down both cases.
Weekly list item number 18.
Malak, this is covered by the order. Similar matter was in this case of the same petitioner, only the period is different. I have already given the order, that is 17/4/2019 in STRV number 112 of 2004. It is covered. In case of the same assessee, same petitioner, only the period is different.
All right. In view of the order dated 17th April 2019, passed by this court in ST REV number 112 of 2004, involving the same SCC for a different period. The present petition is disposed of.
My lord, there it has been remanded to the tribunal.
Yeah. In the same terms. Full stop. The petitioner will now appear before the Sales Tax Tribunal, Orissa Sales Tax Tribunal, on 25th April 2022, along with a certified copy of this order. And the tribunal will consider and decide the matter within 4 months thereafter, in accordance with the aforementioned order of this court. The revision petition is disposed of.
Weekly list item number 19.
None appears dismissed in office.
Weekly list item number 20.
May I please? The petitioner here, my lord, has been engaged in the contract work and done some contract work for staff quarters of the telecommunication division of Sambalpur, my lord. For the labor and service charges, the assessing officer allowed 42%, my lord. And it was enhanced on an appeal preferred by the petitioner. It was enhanced to 50%. Now, my lord, the state went in appeal to the tribunal, and tribunal, on a presumption that I must have escalated the cost of the contract work, again with another presumption, they reduced it to 35%, even much below than what the assessing officer had done.
They can only go to the assessing officer. They could not. To that extent, my lord, going below the deductions allowed by the assessing officer.
Presumption, my lord. The presumption cannot be based on another presumption. It has to be on.
No, my lord. Going through the record,
I must have escalated the cost of the contract, right?
What is the tax effect, sir, and all this?
Pardon, my lord?
Tax
44,000, madam. 44,000. 44,169.
It's a small contractor, a small contractor, it's petty contractor.
To recover this 34,000, you have to spend a lot of money, sir.
Refund, my lord. Is a refund of 44,000, not demand.
Oh. So you'll anyway get a refund.
A refund was refund was granted.
44,000 assessment order. First applied order refund enhanced to 69,000. He wants more refund.
No. It must have been the refund must have got reduced because of the tribunal's order.
No, yes, but tribunal has set it aside.
Yeah.
Remanded back to the assessing officer. So the refund will come down. 44,000 was as for the assessment order. So it will once remanded.
First applied order given it to only 50%.
Nothing. From 2004, this has not even got admitted once. No question framed. 17 years, 18 years. Not even a question is framed. What's the point? I don't know. After 18 years, the STU will again start looking at it. And then again, it will go to the appellate authority, again to the tribunal. There's no end to it. These are all refund matters. I don't press this. Considering that the matter only concerns the amount of refund owed to the SSC. And considering that for 18 years now, the present revision petition, for over 17 years now, the present in the present revision petition, neither has notice been issued nor any question of law framed. The court is not inclined to entertain it at this stage, leaving the question of law open for decision in some appropriate case. The petition is disposed of.
Weekly list item 21.
Both the cases.
Yes. There are only one case.
I think there are another two cases.
None appears dismissed non-prosecution 21.
Weekly list item 22.
No instruction, my lord. On behalf of Mr. Mishra.
Appearing 21 minutes.
Yes.
21. In this matter, the old matter of 2007. In the meantime, the appellant, Calcutta Dock Level Board, probably has complied with the order passed by this honorable court. Let me take instruction whether they have complied with it.
No. We're not adjourning it, sir.
Let's say if it's already complied with.
All right. Counsel for the appellant states that the order in appeal has already been complied with.
No.
So say either this or that. We are not adjourning it.
On telephonic instruction I received today morning itself, they said might have been complied with.
Whatever, sir.
I'm not sure. It also may indicate that if cause of action survives, then I will.
No. Nothing survives. The appellant is disposed of. Yes.
Weekly list item 23.
None appears dismissed in non-prosecution. Both matters.
Weekly list item 24.
24, no instruction.
No instructions disposed of.
Weekly list item 25.
None appears dismissed in non-prosecution.
Weekly list item number 26.
None appears dismissed in non-prosecution.
Weekly list item number 27.
Vincent, may I pray, my lord, may we kindly taken up after lunch?
All right.
Weekly list item 28.
None appears dismissed in non-prosecution.
Weekly list item number 29.
May I please your notes? Your lord, that petitioner being a landless person has applied for the revenue officer for lease of land, my lord. And on basis of the application, my lord, that all the criteria has been fulfilled and the Tahsildar has granted lease in favor of the petitioner, my lord. That your lordship may kindly glance page 10, annexure 1 at page 10 on 24 May 1980, my lord, that lease was granted in favor of the petitioner. And to that effect, my lord, the Tahsildar has directed the record keeper to issue ROR, my lord, that record of rights. Despite that, my lord, that record of right was not created. And in the year, my lord, I have filed representation in the year 82 that in pursuant to such representation, my lord, for issuance of ROR, the revenue officer has not created the ROR. My lord. Thereafter, I have approached this honorable court since the representation for issuance of ROR is pending. So this honorable court directed the Tahsildar to consider the same and pass necessary orders. And in pursuant to the order of this honorable court, my lord, the Tahsildar has made a verification over the plot, and he has given a finding that since the petitioner is not in possession of that land, so ROR cannot be created.
Correct.
Here, my lord, the lease was granted. After creation of ROR, I can only possess the land below. Before that, I can't. If at all I will possess the land, it will be unauthorized.
What is the position of the land now?
Now I am in possession of that land. In the year 1999.
If you say that on that very day you are not in possession, then when you entered into possession of the land?
No, they can't.
And apart from that, this is an order for injunction under section 3B of the OGLS Act. That is applicable. You could have filed appeal against that order.
No. Here, resumption is not under challenge law. And wrong law. The resumption proceeding was initiated, but that has been dropped.
What have you come to the court for, sir, and against what order?
For issuance of record of right law. In view of the order passed by the Tahsildar, the record of right may be created in favor of the petitioner. That is the only limited grievance.
Oh, when did you get into possession? You are already in possession now. When did you get into possession?
By that time, I am in possession, but they are saying that I am not in possession. So that is not a ground for creation of ROR. By virtue of the order of the Tahsildar, as the land has been settled in favor of the petitioner, it is the duty of the revenue authority to create ROR. That is the order, Milo. If your lordship may kindly glance page 10, Milo, that annexure 1 at page 10, in large portion I am reading, Milo. The Kisom is Gharabari and the applicant to pay rent to present village rate, record keeper to correct ROR and intimate record supervisor concerned to correct his office record.
No counter, nothing filed.
Your lordship may kindly see your lordship may kindly see the order dated 22nd September 2002 at page 12.
Yes.
This is the order by virtue of which the lease was resumed. Resumption procedure, it is an order of resumption. It was the last part of this order I am just placing. In my spot inquiry, it is seen that Navakishore Naik is not in possession of any plot, whether in plot number 1 nor in 5. ROR has not been created in favor of Navakishore Naik. So this case has no merit to be considered. So this case may rest here. So, and the last order, another order I will draw your lordship's attention, Annexure 3. This is the ROR has not been in favor of so-and-so and run to consider. So this case may be rested. The Honorable High Court had ordered so-and-so to reporting opposite partner is Tahsildar Bhuvner dispose of the representation and the petitioner annexed as Annexure 2 series in this writ petition within a period of 6 months from the date. It is revealed of order dated so-and-so passed by additional that the lessee is not in possession in plot number 8. Therefore, this case is dropped. So his claim of this acquisition of right on the basis of this lease was twice decided by the additional Tahsildar. Once by on its own motion, another by virtue of the direction of this honorable court in a writ petition. And both the cases there, it is held that it is dropped. The lease has no value because he is not in possession. Whatever the wrong or right may be, that order has been passed twice. So if he is not in possession, that is the finding of the, and if he is agreed by this resumption order, that means if lease is granted, it is again resumption, it is a resumption proceeding and government is now recorded in government khata. So let him file appeal against this order.
So what do you want to do? 22nd July 2009, you are aggrieved by that order?
No. That case has been dropped, Milo. Resumption proceeding was initiated, but it has not been resumed.
No. The resumption drop means
that order.
No, if it is dropped, then you're not agreed with this order.
No, dropped means that proceeding was initiated and it has been dropped.
No, are you aggrieved or not is the question, sir.
No. That order is not against me, Milord.
No. This order holds that you are not in possession, and you're saying it is not against you.
By that time, Milord, that ROR has not been created. So
no, let us be clear. Let us be clear.
Yes.
Are you agreed by any portion of this order at page 1516?
Annexure 3.
The Annexure 3, Milord, that Annexure 3, so far as the mine contention in the earlier repetition, Milord, that lease was granted, but ROR was not created. Thereafter, I came before this honorable court.
You're not answering the question.
Yes.
You're going round and round in circles. Are you aggrieved by this order at pages 1516?
Annexure 3, yes, 16, Milord.
Are you aggrieved?
Yes.
If you are aggrieved, then you file an appeal.
Go for appeal.
No. The appeal, Milord, there is no provision for appeal, Milord.
Against the Tahsildar's order.
That page 10, Milord, that is the sole solitary question, Milord.
No.
Page 10.
Is there appeal or not? No appeal.
Here, if at all this is a mutation case, Milord, appeal will be preferred. But this case has been dropped.
Case has been dropped means your lease was not accepted in view of the fact that you are not in possession. So you are aggrieved by that order that is a resumption to the land of the government to its government kata. So if you are aggrieved, you have to file appeal against that. That is OGLS Act, section 5, I think.
Appeal. That is 7A.
7A, correct.
No. That so far as the lease part is concerned, that is still in force, Milord. That order was not.
Lease is not in force.
That order was not recalled. And so far as the issuance of ROR is concerned, Milord, the Tahsildar has never asked the petitioner to whether the lease is recalled or not. That order is still in force, Milord. That so far as the order dated 24/5 to 1980, that order is still in force, Milord.
How can it be, sir? Subsequently, the same Tahsildar has passed these orders.
Yes,
twice over he has passed those orders. So how can a 1980 order still survive?
No, that so far as the 1980 order, that was not carried out.
Correct. So now he's finding he's not in possession, so you're not entitled to an ROR.
No, possession, that I am in possession, Milord. I am in possession.
The factual finding is that you are not. The factual finding is that you are not.
Yes, that my contention. My contention is that still I am in possession, Milord.
That is your claim. That is not the finding of the Tahsildar.
Fresh inquiry may be conducted. During the year 1999, Milord, super cyclone was there.
And he conducted the inquiry. That is mentioned in the impugned order. He conducted the physical inquiry.
Yes, that is in the year 2002, Milord. In the 1990.
See, these are factual questions, sir. We can't go into that in the writ petition.
Yes. Or your Lordship may direct the Tahsildar to conduct fresh inquiry so that if I will in possession, then ROR may be created.
That's possible. If he's claiming to be in possession.
No, this fact he can raise before the appellate authority, but that should be.
No, is there an appellate authority?
Yes, my lord. Sub-collector is the appellate authority.
No.
Against that, no. How will you say that? This is an order by virtue of which the land has been resumed to the government. Your lease has been invalidated.
No. Under which act, sir?
That is under the OG, because the lease was granted under the OGLS Act.
Okay.
The all Bhubaneswar land, the lease was under the OGLS Act. Before the sub-collector, let him pray.
The petitioner is aggrieved.
My lord, in para 6, he has admitted that there is a resumption proceeding. The petitioner in para 6 of the writ petition.
That is on basis of the record.
He himself has stated, however,
now he claims that resumption proceeding has been dropped.
No, drop means the original lease was cancelled. That the entire order is to be read, not a single word drop.
Anyway, if he's aggrieved, then he can go.
Yes, go to the sub-collector. But it is under OGLS Act.
By an order dated 22nd July 2009, passed by the Tahsildar Bhubaneswar in Wasteland case number 1034 of 1978. Paragraph. There is a remedy by way of an appeal available to the petitioner against the aforementioned order, before the sub-collector. Paragraph. Consequently, leaving it open to the petitioner to prefer such an appeal, the court declines to entertain the present petition if such appeal is filed not later than 2nd May 2022, accompanied by an application for condonation of delay, giving the reason for the delay on account of the pendency of the present petition, such application will be considered on its merits by the appellate authority. The court clarifies it has not expressed any view in the matter. The petition is disposed of in the court.
Weekly list item 30.
None appears dismissed in opposition.
Weekly list item 31.
31 not maintainable, my lord.
Not maintainable. Disposed of as such.
Weekly list item now 32.
My lord, in this case, item number serial 32, my lord.
May I request your lordship?
Yes, please.
My lord, this petition, by this petition, the petitioner is complaining about the migration of the state government from manual registration of documents to e-registration. My lord, this has been going on for the last 20 years, since 2008. While the petitioner is not against e-registration, but before migrating to e-registration, certain corresponding amendments were required to be carried out under the Registration Act and the IT Act, without which registered documents become inadmissible in evidence. My lord, for one, my lords, if your lordship takes section 1, subsection 4, subclause 4 of the information technology.
No, Mr. Mukherjee, tell me one thing.
Yes, my lord.
This petition was filed more than 12 years ago.
Yes, my lords.
So during these 12 years, e-registration is carried on without amendment to the Act.
Yes, my lords. No, ma'am.
So de facto, therefore, there have been e-registrations continuing.
Absolutely.
So at this stage, suppose we say there could not have been e-registration without amending the Act. It will invalidate all those e-registrations.
No, my lords. What is the need of the hour is to perhaps direct the government to give a retrospective amendment to the statutes, my lords.
Not filed any reply, sir.
They have not filed a reply. We have filed a counter, my lord, a specific stand, my lord.
Where did you file a counter has been filed?
Yes, contention of the petitioner is that this e-registration scheme has been implemented without making necessary amendments to the rules, my lord.
Yeah.
Our reply to that is, my lord, we have made, the government of India has made an amendment in 2001, my lord, to the Registration Act 1908. Thereafter, taking a cue from that, the IGR, my lord, the state government, after obtaining sanction from the state government, in 2002, the Orissa registration rules has been amended. Thereafter, in 2009, again it has been amended. All safeguard measures have been taken, my lord, and it has been implemented since 2010.
My lords, the copy of the counter has not been given to me, one. And second is, as far as these amendments which have been spoken of, my lord, they do not cure the defect, my lords, which I will point out to you, take your lordships to the case. The amendments which my learned friend is talking about, the amendment of 2002 and the amendment of 2009, do not take care of the defects which continue to subsist in the absence of the amendment which I seek in the Registration Act.
He is not challenging the amendment, my lord. He's seeking direction because the amendments have been not.
No, your lordship, my learned friend may see the WPC number 13896 of 2017.
No, I'm talking about the first case in the list, my lord. That is 14048.
Only take this matter. This is the comprehensive writ petition which has been.
No, but the fact remains that amendments have been carried out.
The issues are same.
No, my lords, if your lordship sees, amendments have not been carried out so as to address the difficulties that continue to, or the illegalities that continue to subsist despite the amendments. Now, my lords, if tomorrow I were to produce this e-registered documents as evidence in a suit, they would become inadmissible for non-compliance of certain.
Has it happened somewhere? In the last 12 years, tell us in any one suit where you produce this e-registered document and the court said it's inadmissible. Tell us one instance.
If in trial court I am confronted with one such document, I would definitely challenge it.
No. Give us an instance, please. A concrete instance where a court has said, since this has been registered without amending the act, I'm not taking it on board.
To my knowledge, I am not aware of any.
Then when the cause of action arises, you file the petition.
Yes, my lord.
If such a cause of action arises, you by all means file. We'll give you liberty to do it.
My lord, serial number 2. That is WPC number 20923 of 2010, my lord. If your lordship will kindly glance, my lord, in this case, we have revived that file with certain documents in miscase. That is miscase number 8093 of 2016, where this honorable court has directed on 16/1/2017, allowing to revive on the certain documents where the document that has been given by the IGR itself, my lord, they have not amended properly. That document has been annexed in this miscase. Therefore, after revive, my lord, I am filing one amendment petitions, which has been on the record, and address is not found. The private opposite parties address is not.
What is the point in the petition? You tell us.
Yes, my lord, I have given my short notes, and I have, if your lordship glance, and I am certain giving the copy with regard to that, what are the informative and what are this, and I, since amendment is not allowed, I may be permitted to give this document that is dated 25/1/2011, where the amendment is not properly taken care, that has been inflict, my lord. If that has been properly,
the amendment is not under challenge, my lord.
Since this is not, therefore our document is not validity. That is my contention.
You challenge, instead of an amendment, you file a substantive petition.
Yeah.
You say, in all these 3 petitions, the grievance raised is that e-registration of documents has been mandated by the government of Orissa without corresponding amendments to the statutes in question, to the applicable statutes.
IT and registration.
In reply to the present petition, it is pointed out by the state government that e-registration was undertaken pursuant to the amendments made to the Registration Act 1908 by the Government of India, by the Registration and Other Related Laws Amendment Act 2001. Full stop. Correspondingly, amendments were made to the Orissa Registration Rules 1988 by a notification of the Board of Revenue dated 30th May 2002. It is stated that the amendments were made to give effect to the e-registration project. Further, the Inspector General of Registration, with the approval of the state government, has amended the Orissa Registration Rules 1988 by a notification dated 6th March 2009 of the Board of Revenue. So the rules are now called the Orissa Registration Amendment Rules 2008. A Gazette notification dated 24th September 2001 containing the above amendment and a copy of the notification dated 30th May 2002 have been enclosed with the counter paragraph. If there are still any instances where a registration certificate, e-registration certificate has been declined to be acted upon by any authority in the state of Orissa on the ground that it is without the backing of a statute, it will be open to any of these petitioners to bring such individual instance to the attention of the court and seek appropriate directions. So, the above clarification, these petitions are disposed of. As far as the applications filed in writ petition civil 2093 of 2010 seeking amendment of the writ petition, challenge the amended statutes as mentioned here and before. The court is of the view that instead of entertaining the amendment application, the petitioner should be permitted to file a fresh petition if any cause of action survives. It is so ordered.
My lords, just one more prayer, my lords. Your lordship may not confine the relief only to the petitioners. If anybody is aggrieved by...
That's right. I've said anybody.
My lord, one thing,
Your lordship,
maybe pardon to mention, my lord. In letter dated 25/1/2011, the IGR has given to the letter to the commissioner. This amendment is required. That has not been admitted. They have done this, my lord. It may be taken into consideration, my lord.
We've said that, sir. You can always file a separate petition. Yes.
Weekly list item 33.
In his case, the term is over, new contract has joined.
Or counsel, the petitioner states that the petition has been rendered infructuous. Disposed of as such.
Weekly list item 34.
33 I am for the opposite party.
All right.
Interim order may be vacated.
Yes.
Item 34.
None appears to Mr. Non-prosecution.
35.
None appears to Mr. Non-prosecution.
Weekly list item 36. Weekly list item 36.
So you have to speak into the mic. We can't hear you, sir. Please come speak into the mic.
I made a statement, item number 32, that our term is over. I'm sorry. It was record for 33. Sorry.
Item 32, my learned senior is appearing for the third party with whom state government has entered into agreement for implementation of the project. My lord.
Anyway, 32 should be said dismiss the non-prosecution. All right.
Into different order.
Oh, 32, I don't know. I don't understand. 32 is
32, my lord. What has happened? State government has entered into an agreement with a third party, OCAC, and another private party for implementation of this project, e-governance project, my lord.
Huh.
My learned senior is appearing for that private party whose term is over. That's what he's saying.
So what is that? I don't know.
My lord, his appearance may be noted.
That's all. Okay. All right.
Weekly list item 36.
None appears dismiss the non-prosecution.
Weekly list item 37.
I'm for OP number 1.
All right. None appears dismiss the non-prosecution.
Weekly list item 38.
None appears dismiss the non-prosecution.
Weekly list item 39.
May I please, your lordships? And in this case, the petitioner has challenged the letter of requisition for initiation of a certificate proceedings against him at Annex 4, my lord. And the facts of the case are as such that the petitioner is a scheduled caste person and had availed a loan facility from OP number 2 for buying a tractor in 2001, my lord. After that, due to default, a requisition was made by OP number 3 for initiation of a certificate proceeding to OP number 4. In the said certificate proceedings, certificate proceeding was initiated in 2008 and concluded in 2011. The order sheet is annexed at page number 18, my lord. In the said the certificate proceeding was closed. The amount that was due from the petitioner was realized. After the realization of the said amount, 3 months after the realization of the said amount, the petitioner requested the OP number 3 for the release of his mortgage, that ROR and the no due certificate. But 3 months after the closure of the certificate proceedings, he receives another letter in which the OP number 3 has made another requisition for a balance amount of 10,000 rupees and a penalty of 30,000 rupees, a total of 41,975 rupees. In the initial requisition was for 1 lakh. The letter of requisition that was in 2008, that was for 1,10,000. 1,14,810. the said amount has been realized from the present petitioner. After realization, when the petitioner approached for release of his mortgage land documents and no due certificate, he is being served with another requisition for amount of 41,975. My lord, now in the OPDR Act, there is no such provision. After the certificate proceedings has been closed in respect of a given transaction, a second certificate proceeding in respect of the said amount that can be initiated. There is no such provision, my lord. The relevant provision in the OPDR Act is Section 4 of the OPDR Act. I may permit her to read it, my lord.
So this 40,000 rupees you saved in 2011. There's a stay of recovery of 40,000 rupees.
My lord, that is the amount that is asked of me after the certificate proceedings have been opened.
Correct. So how much have you saved? In the last 11 years, you've not paid anything. In the 40,000, you've not paid anything, sir, in the last 11 years. So you've saved quite some amount, right?
But in the certificate proceeding, the opposite parties had every opportunity. If there was any further,
Just come to para 12 and 13 of the counter affidavit.
My lord. After closure of the certificate case, our corporation, before releasing of the mortgage property on recalculation, loan there being principal outstanding of 10,768 and interest to the tune of 31,027 on 25/7/2011. The said principal outstanding of rupees 10,786 was inadvertently not mentioned in the requisition for certificate, where the total outstanding was shown rupees 1,14,810. A copy of the letter addressed to the opposite party number 4 on 28/9/2011 is annexed.
Read on.
That there is no bar under the OPDR Act for initiation of a second certificate proceeding for recovery of any outstanding dues which has been omitted in the original certificate proceedings. Hence, initiation of a second proceeding under the OPDR Act for recovery of the outstanding amount is neither bad in law nor an arbitrary action, my lord. But in case there was any further amount there was a mistake in calculation, the OPDR Act has a specific provision for addition of that amount. The proceeding went on for 3 years, but in throughout the proceeding they have not raised the amount. They have not raised the additional amount. My lord, the relevant provision is Section 10 of the OPDR Act.
There's some estoppel. Suppose they don't correct the amount at that stage, can they never correct it subsequently? Is there an estoppel? Why should they not collect the remaining 10,000 which is due to them? That's the only question.
My lord, the requisition of 2008. After that,
you can easily pay 40,000 rupees, sir, if you're really interested.
Sir, I am a.
This tractor trolleys were with you only or not with somebody else?
That.
Lord, I think, Lord, I am not appearing for the private opinion, but 2-3 are represented by some.
No. This whole thing is for release of a tractor, mortgage property, right? What is the mortgage property?
Mortgage property was a land manner. Schedule of the state. It's a khata number 239, plot number 1242 in Dhenkanal district, my lord.
So what happened, sir? It's still with them.
My lord?
It's only mortgage, which means you must be using the land and working on it. Is it agricultural land? What kind of land is this?
It's a my lord,
if it's a tractor and trolley that you brought,
my lord,
it's obviously agricultural land.
My lord.
So you want the mortgage released, correct?
My lord.
Why don't you pay this and get it done?
Well, but the amount I have already paid in the certificate proceeding. In the certificate proceeding,
They have telling you they made a mistake. Some 10,000 was still left out, and therefore they have to initiate a further proceeding to recover that.
sir, but my lord,
See, by not paying 40,000, you're depriving yourself of land worth several lakhs of rupees. Is it practical what you're doing?
my lord, then that 10,000 rupees, the certificate proceeding
If you
provides
had
that.
paid the 10,000 then, that is 11 years ago, you wouldn't be in this predicament today. Today you'll end up paying far more interest than the even value of the land now.
Even in respect of that particular 10,000, I can raise my objection, my lord. The OPW.
You raise, sir, fight it till the end, but at the end of the day, your client is going to end up paying lakhs of rupees. This is the difficulty, not getting proper advice. And no rejoinder has been filed to this counter affidavit. So you do not dispute the fact that you still owe them 10,000 rupees, on which interest itself is worked out to 30,000 rupees. This is in 2011. Now I wonder what that interest amount will be. This counter affidavit was filed in 2012, sir. More than 10 years ago, 7th April 2012.
I'll be permitted 1 week time, I'll file the rejoinder, my lord.
What will come out of rejoinder, sir? Basically, you will deny all this, correct? He says 10,000 is owed to me. In your rejoinder, he'll say, no, it is not owed to you. That's it.
My point is that they cannot ask for another recalculation.
Why not? Where is the prohibition? The
no
point he's making is show one provision in the OPDR Act which says once a certificate proceeding is initiated, it cannot be initiated for a further sum.
Well, but there is provision for addition during the certificate proceeding. Even
Assuming if that is not done, where is the prohibition saying if you do not do it for addition, you can never do it? Where is the prohibition?
In case of that, my lord, they can make another requisition too.
That's what this is. This is all of this is the further requisition, which is what you came here and got a stay on.
Any citation, any law that a second proceeding cannot be initiated after the realization?
Right now, I don't know, but
as far as the act is concerned, there is no bar, there is no prohibition.
Madam, I believe there are some citations. One day time maybe when my
no. It says a challenge in the present petition is to demand notice dated 29th September 2011, issued by the Orissa Scheduled Caste and Scheduled Tribe Development Finance and Corporation Limited, Venkanar, requiring the petitioner to pay the balance principal amount of rupees 10,768 together with interest of rupees 31,027, thus totaling 41,795 as of 25th July 2011. Paragraph. While issuing notice in the present petition on 10 January 2012, this court stayed the operation of the above demand notice. That stay order has continued ever since. The main contention of counsel petitioner is that there has already been a certificate case instituted against the petitioner for recovery of a sum of rupees 114,810. Full stop. With full satisfaction having been recorded in the said certificate case, nothing more was owed to the opposite party by the present petitioner. Full stop. According to him, once a certificate proceedings has ended, with the full amount having been recovered, full amount for which it was instituted having been recovered, there cannot be another certificate proceedings on an alleged balance amount due. Stop. It is further contended that under section
10, my lord, provides section 10 provides that the addition can be made.
Section 4. Counsel for the petitioner further draws attention to section 10 of the Orissa Public Demands Recovery Act 1962 bracket Act, which permits the certificate officer to amend a certificate, open quotation, by addition, omission, or substitution, unquote, which provision was not resorted to in the present case. So according to him, therefore, the entire proceedings seeking to recover further sum from the petitioner is illegal. Paragraph. In a counter affidavit filed in the present petition, to the present petition by opposite parties 1 and 2, way back on 17th April 2012, it was inter alia averred in paras 12 and 13 as under. No, 12, 13 and 14 as under. Paragraph. No rejoinder has been filed to the above counter affidavit till date. Paragraph. Counsel to the petitioner has not been able to point out any provision of the Act which bars the opposite party from seeking to recover an amount which was left out of the original certificate proceedings initiated in the first place. Full stop. While Section 10 does provide for amendment of a certificate, it does not mean that the failure to invoke that provision would preclude the authority from initiating fresh certificate proceedings for recovery of any balance sum found still due from the petitioner. In the absence of any statutory bar, the court sees no illegality, finds no illegality having been committed by the opposite parties in issuing the impugned demand notice. Paragraph. See, this is still a demand notice. You can reply to this demand notice and show that you paid this 10,000 already. You can still participate, sir. This is a demand notice. You go before the certificate officer. If you have your account book, show them that you paid the 10,000. Consequently, the court is unable to, not persuaded to interfere with the impugned demand notice. The interim order stands vacated. The petition is dismissed, but in the circumstances, no order is dismissed.
Weekly list item 40.
Item number 40, your lordship, no instructions.
No instructions. This post office.
Weekly list item number 41.
Item 41, I am placed on behalf of Mr. N.C. Misra, appearing for the opposite party. So
None appears to the petitioner, dismissal not possible.
It become infructuous, my lord.
All right. A miss case, just put the miss case.
Miss case will be withdrawn.
Dismiss is withdrawn.
Weekly list item 42.
Again, miss case. Put civil review also. It says none appears, dismissal not
I am for OP 3 and 4.
All right.
Weekly list item 43.
Again, miss case, none appears, dismissal not possible.
Weekly list item 44.
Miss cases, put all the miss cases.
I'm on behalf of the opposite party, your lordship.
Right.
Weekly list item 45.
45, the miss case filed by the OP number 3 is dead. Therefore, infructuous.
The applicant is stated to be dead. Dismissed as such.
My lord, I am for the petitioner, my lord.
All right.
Weekly list item 46.
46, my lord, is a dispose of case, my lord.
Already disposed of. Inquiry report is there. The RDC
The
is.
inquiry report has been perused.
My lord.
No further directions are called for.
Weekly list item 47.
This case, none appears, dismissal not prosecution.
Weekly list item 48.
This case, none appears.
I'm for the opposite party, Your Honor.
All right.
Weekly list item 49.
49 is lordship for revival of the writ application in terms of the Supreme Court's order. The writ application may be revived, my lord. The batch is coming on 20th of June, my lord.
All right. 20192 of 2017 for the state reason stated therein, the application is allowed. WP Civil 1461 of 2007 is restored to file. 2945 2018 for the reason stated therein, the application is allowed. The amended writ petition is taken on record. In the main writ petition, say list on
20th of June.
29th.
29th of June.
29 June 2022. All right.
Your Lordship, I am for the opposite party. Your Lordship.
All right, sir.
All right.
Weekly list item 50.
Item 50 mainly file was misplaced. May I permitted to verify the record of matter of 2008?
So, okay, sir. So, as it is a recall order, disposed of case. You just put MC number 7881 of 2009. There's no merit in this application. It's dismissed as such.
Problem. Supplementary list, fresh admission, item number 1.
Item number 1, Your Lordship, I pray for 1 week time to obtain instruction, my lord.
No, we're not adjourning, madam.
My lord, the previous conducting council has expired, my lord, and we have to obtain the instruction that the client will continue with us or not.
No. You say counsel for the petitioners has no instructions. What is the matter about? Let's see.
The matter is the appointment of ad hoc district judge, my lord. It's the challenging the advertisement number annex 3, Your Lordship.
Yeah, that's all. You see, considering the passage of time, court does not consider it appropriate to entertain the present petition any longer.
May I?
In any event, the petitioner's age.
Petition is pending before the authority.
Petitioner is well above 61 years now, and it's not possible for him to be granted any of the reliefs prayed for.
Let's say permitted to withdraw it with liberty that if the cause of action survive, then the petitioner.
He's 61 years old, madam. How can a cause of action survive? How can he get into the superior judicial service after he's 61? The petition is dismissed. Right.
Supplementary list item number 2.
May please. Para 8 minute revenue has formulated the question number A and B. Whether on the fact and second the case, the tribunal justified law deleting the addition made under the head of unexplained sundry creditor and rupees so and sundry debtors rupees so under section 68 of the Income Tax Act.
All right.
Here fact remain not the tribunal allowed this appeal in favor of the assessee on the ground that the assessing officer not rejected the bookshop account, though it was reflected in the bookshop account, but he has not explained the creditworthiness of the sundry creditor. Therefore, 66 is applied here. In similar view, the Honorable Kerala High Court has passed an order in favor, and that has been approved by the Supreme Court. I have referred in my appeal memo in paragraph in running page 7. The Honorable Kerala High Court, this is the judgment, copy of the judgment. Union Equity versus CIT, and it cannot be doubted that it is for the assessed to prove the identity of the creditor as sole creditworthiness. The genuineness of transaction should be proved. SLP against the judgment has been dismissed by the Honorable Court. It's reported in 1993-201 ITR.
No, this is on the facts.
I understand that the bookshop account has been accepted. Sale and purchase not disputed by the assessing officer, but the fact remains the creditworthiness and the section 68, if I am permitted to place me not. Section 68 is specifically says where any sum is found credited in the books of the assessee maintained any previous year, and the assessee offer no explanation about the nature and source of the expenditure offered by him is not, in the opinion of the assessing officer, satisfactory, the sums of creditor may be charged income tax as the income assessed of the previous year. Therefore, my humble submission is not, he has not proved his creditworthiness of the creditor and debtors. Therefore, it is a pure question of law. Your Lordship may consider it.
How is it pure question of law, please? The department is in appeal against an order dated 31st January 2018, passed by the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack, bracket IT-80, in ITA number 20/CTK/2017, the assessment year, bracket AY, bracket 2011-12. The question sought to be urged by the revenue is colon, take from page 8, question A. The ground on which the IT-80 accepted the plea of the SSC and set aside the additions made by the assessing officer, bracket AO, is that the AO had not rejected the books of account of the SSC, in which all the details concerning the sundry creditors were disclosed. Even the purchases and sales as disclosed in the accounts was accepted by the AO. The the Commissioner of Income Tax Appeals, bracket CITA, had called for comments from the AO on the documents disclosed in the appeal proceedings. In his remand report, while the AO doubted the balance of sundry creditors, as far as the books of account were concerned, he accepted the purchase and sales figures. Full stop. Learned counsel, the department sought to place reliance on the decision of the Kerala High Court in MA Uniri Kuti versus CIT 1992 198 ITR 147 bracket KER to urge that it is the burden was on the SSC to prove the identity and creditworthiness of the creditor in terms of Section 68 of the Income Tax Act 1961. He further pointed out that the special leave petition filed against the said decision by the SSC was dismissed by the Supreme Court and reported as 1993-201 ITR bracket ST dot bracket 23. So he accordingly submitted that in the present case, the SSC had not proved the genuineness or creditworthiness of the creditors. Paragraph. The fact remains that a full disclosure of the creditors was made by the SSC in the books of account, which is not doubted by the AO. Full stop. Unless the AO is able to reject the books of account for non-furnishing of a proper explanation of the SSC, it is not possible to accept the plea of the department that in the present case, the SSC had not discharged the burden of showing the genuineness and creditworthiness of the creditors. Also, after all, the books of accounts are audited in terms of Section 44 AB of the Act, and therefore cannot be lightly rejected by the AO. Paragraph. Consequently, the court is unable to find any error having been committed by the IT-80 in allowing the SSC's appeal in the manner aforementioned. No substantial question of law arises. The appeal is dismissed.
Supplementary list item number 3.
May I please, my lord? My lord, in this case, the appeal is filed by the petition that Mahanadi Court of Invalidity is in this case, there are 6 or ITS also filed on similar grounds. All ITs against the ITT order, 6 IT has been filed. There are common grounds. They are not posted for hearing today.
Tell us what is this, and then we can.
My lord, my predicament is yesterday's supplementary list it came up. In fact, the copy of the has been served to the opposite party, but the present departmental DR he doesn't have the copy. A date may be fixed. All the cases I will be clouded. Any date in April, I will do the hearing. My lord. I'll file the paperwork also and the chart also prepared common because all the grounds are common in all the 7 years. 1 year it's come up for hearing today, 9-10.
It's only a remand to the AO, sir.
No, exactly, but that has to be decided by the ITAT or maybe by the High Court, by the question of law is involved. Well, like a depreciation of leasehold land. Now, Mahanadi Courtfield takes leasehold land, and that land, no depreciation has been allowed. There are other grounds also, but I would like to take one
on a leasehold land. How will depreciation be allowed?
It will be available because this is capitalized in the account, and there are certain conditions. So,
no, but for all of this, it has only been sent back to the AO, correct?
They have set a certain not all they have set aside to the AO. They have allowed some, partly allowed some, and some they have set aside to the AO. So there are common on another 6 appeals are pending. I will give the list to by the end of the day.
Just along with ITA numbers, just give the numbers. By the end
I'll give it end of the day.
On. You have the paper books.
He has not solved the copy. All the copies be solved. Previously I have solved. I will again solve.
On 14 July, copies of the paper books be served in advance to counsel for the revenue. Right.
Supplementary list item number 4.
Please, your lordship, this is PIL petition, your lordship. The villagers has given a petition to the authority for changing the school name, your lordship. Rengta Government High School, Mahasindhu to the Mahasindhu Government High School, Mahasindhu, your lordship.
This is all not PIL, sir.
No public interest involved.
Absolutely. The prayer in the present petition is for a direction to the opposite parties to change the name of a government school.
My lord, in the department of school and mass, there is a committee.
These are not matters
to deal with this matter, your lordship. There is a committee, your lordship.
Sorry, you want to withdraw this PIL, you can. If you want to withdraw, you can. We are not entertaining this, sir.
Due to wrong, the Rengta village is not exist till my lord nowadays, your lordship. Kindly see my
petition is dismissed.
Supplementary list item number 5. Item number 5.
And 4 permitted to withdraw, your lordship.
Item 4, you say counsel the petitioner seeks leave to withdraw this petition with liberty to pursue the matter with the authorities. This most of us withdrawn with liberty space.
Supplementary item 5.
May I please, Your Honor, this read petition filed against the NH authority that Lord Sakhigopal Temple, Lord Krishna Temple is situated just side of the NH 203 and it is very nearer to Lord Jagannath Temple Puri. But the NH authority have not constructed the bus stand. For the devotee, they have not constructed any work, bus stand and drainage and Shauchalaya, everything he has not constructed. For which we have filed a reprehension petition before the project director NS 203, who forwarded the same to the contractor, who OP number 3, and that same is pending before the contractor. So, my lord, devotee.
All right, the petitioner's grievance petition, Annexure 1, be examined by the project director, National Highway 203, bracket opposite party number 1. And after notice to the petitioner and opposite party number 3, a reasoned decision should be given not later than 25th April 2022. With the copies of the decision being made available to the parties not later than 2nd May 2022. The court clarifies it is not expressed any view in the matter. Petition.
Supplementary list item number 6.
May I please, in this matter, the petitioner challenged the notice under section 148 of the IT Act, page 17, annexure 1, relating the assessment of 1314 beyond the period of limitation. And in that, in first round of litigation, your lordship has directed to the deputy commissioner to consider the aspect. And he has considered the aspect and stated that as per the relaxation of certain relaxation, so that the date has been extended from 20 to 21 manner. So in these similar aspects, the case batch of cases has posted on 11th July 2021 for consideration.
Annexure 17 is a necessary satisfaction of the PCIT of Bhubaneswar Urban, not JCIT.
Anyway, we're just issuing notice. Notice, Mr. Chimanka accepts notice. Reply within 4 weeks, rejoin of the next date. No coercive steps be taken pursuant to the impugn order. Impugn notice. List on 11 July.
Extra copy mechanism.
Yes, yes.
Supplementary list for orders item number 7.
May I please, your lordship, as per lordship directions, I have already filed an affidavit yesterday, and the report and this respondent being present has already filed the affidavit, and the demand draft of rupees 1 lakh has also been made ready to be handed over to the appellant.
My client is present.
Ask her to come and receive it, please. Counsel for the respondent hands over a demand draft in the sum of rupees 1 lakh favoring the appellant, who is present in court and has received it. Yes. Well, how much is the balance due now, sir?
Miller, balance of 3 lakhs. And I have also given schedule of the time for making
an affidavit has been filed by the
no copy served.
Yes, I will serve the copy.
Respondent giving a schedule for making the balance payment. A copy of the said affidavit be served on counsel for the appellant during the course of the day. When will you pay it, sir, in terms of the schedule?
Miller, in the he has made a prayer for grant of 6 months time for making payment of the entire amount.
No. When is the next installment? How much are you paying in the next installment?
Another 2 months, the remaining 2 lakhs in this way. And
no. So we'll fix a date so that you can bring the 2 lakhs, sir.
At the end of
son is studying in the school.
2 months. At the end of 2 months, 1 lakh will be paid in this way. He wants to.
Which para of your affidavit have you set out the schedule?
That affidavit, yes. Those. Yes.
This is an affidavit dated?
No, affidavit dated 15/3/22. That is not on record.
The affidavit stated to have been filed by the respondent be brought on record. What is the schedule, Mr. Barley? You would have read it. What is he saying?
The balance 3 lakhs he wants to make. So far as the time schedule for making payment of the balance 3 lakhs to the appellant towards her permanent alimony as per settlement made between the two parties, which stands reflected in the order of this honorable court dated 27/1/20 is concerned. It submitted here that the respondent, in view of his recent financial condition, ceased to make payment above amount to the appellant within a period of 6 months at the rate of 2 lakhs at the end of every 2 months for the date of order of this honorable court.
So, I'll fix it on 25th April. You bring 1 lakh.
Also, that is not the settled amount. That is because I have given all the documents and the land stood in the name of the respondent and others. He has already remarried and having child. The appellant son is studying in the school, and since more than so many years lapsed, not a single payday during marriage, more than 13 lakhs, 15 lakhs they have spent, given 5 lakh cash.
All right. Anyway, so as undertaken by the respondent in the said affidavit, which has been read out by counsel for the respondent, he is assured to pay rupees 2 lakhs at the end of every 2 months. Stop. List on 27th April 2022 to enable the petitioner, to enable the respondent to make the payment of rupees 1 lakh as assured by him by way of a demand draft. We listed on 27th April.
Supplementary list item number 8.
Miller, one thing, just in the demand draft, I was directed to make some rupees 1 lakh. But at the time of preparing the bank draft, the bank officer having carried the impression that he requires a demand draft of 1 lakh 500. The demand draft has been prepared on the for 1 lakh 500. In fact,
right in the beginning, you say demand draft for 1 lakh 500 has been handed over.
Yes.
To the appellant who's present in court. Audit.
Supplementary list item number 8.
My lord, the department has filed the appeal. My lord, there is delay of 106 days.
Alright. So the delay of 106 days is not satisfactorily explained. The delay is accordingly not condoned. Since the application for delay, accordingly the appeal is also dismissed. Alright.
Supplementary list item number 9.
Instructions to appear in this particular matter, Your Lordship would permit me, I'll file my vakalat by Monday. There's a miscase for dispensing with filing of certified copies of Annexure 2 and 3. So Annexure 1 is the impugned order, it's the order of the tribunal. So I'd only pray Your Lordship may dispense with filing of Annexures 2 and 3. There's the CIT appeals order.
6 of 2018, for the reason stated, the application is allowed. Right. That's the only defect?
Sorry,
is that the only defect?
I have to check with the other defects.
Counsel for the appellant undertakes to remove the other defects, if any, before the next date. List on 21st April.
21st April.
April.
My May may be indicated. I'll file my vakalat.
All right. Just put down Mr. Karsni.
Supplementary list item number 10.
Obligement.
Supplementary list item number 10.
None appears this now.
Supplementary list item number 11.
May I please, Your Lordship? My Lord, this CMAPL has been filed for.
My Lord, item number 10.
Yes, come.
My Lord, item number 10. Actually, this matter was dismissed for non-appearance of the counsel for the petition for lost sight of the list. So kindly restore the application, my Lord, petition.
No, what is the main writ petition, sir?
My Lord, this is a public interest litigation against the illegal mining activities of opposite parties. My Lord, one vigilance case also was registered against this Deepak Gupta, opposite party number 19. My Lord, NBW also has been issued against all his family members, but till now vigilance does not take any action against them and also does not arrest them. So my Lord, also another matter pertaining to this is pending, which I humbly request my Lord to kindly tag criminal revision 702 of 2013.
So what is this? You've made some 25 respondents.
Yes, my Lord. Lordship, may kindly see the prayer portion, my Lord. Now, he is in a PIL, my Lord, a man of Cuttack. Now, is alleging that in Keonjhar there was a mining scam in the year 2007, and these persons were also facing criminal prosecution. And in spite, and his allegation is that no criminal prosecution is being launched, and they are being granted bail. And the prayer portion is very surprising, my Lord. Second prayer is to direct the cancel of interim bail granted to OP number 19. Third prayer is direct for immediate arrest of OP number 20 to 25 for realization of the scam money from them.
The CMAPL, the court is not satisfied with the reasons given in the present application. It is accordingly dismissed.
Supplementary list item number 11.
May I please, Your Lord? My Lord, the CMAPL has been filed for restoration of writ application 4230 of 2009, my Lord, which was dismissed on 16 to 2022 due to non-prosecution. And the reason being, my Lord, the non-appearance, the reason of the non-appearance is my name was wrongly.
What's the main matter, sir?
The main matter, my Lord, the petitioner who is a retired government employee who was working as a head clerk in the collectorate of Dhenkanal, and then was, my Lord, now Anugod.
my lord, has retired since 2006, my lord. But till date, my lord, the post-retirement benefit have not been given to him. Only the provisional pension he is getting. Even though, my lord, against him there is no proceeding, no inquiry, nothing was there. Still then, the petitioner had also approached the learned tribunal, and the learned tribunal has passed the order at Annexure 9 directing the authorities to consider his case, my lord. Thereafter, Lordship have a glance, page 29, Annexure 10. The government has also directed the collector Dhenkanal to consider the case of the petitioner and to do the needful for payment of his post-retirement benefits. Till then, it has not been given to him. Though the petition had been to the office of the then collector, now also the collector Anugul, or time and again, my lord.
Right. Cross reason stated therein the applications allowed. Writ petition civil 4230/2009 is restored to file. The main writ petition said, despite notice having been issued in the present petition way back on 29 June 2009, till date, no counterfeit has been filed. By any of the respondents. That the grievance of the petitioner is about non-release of the retirement dues. Including provident fund, gratuity, pension, etc. Paragraph. Earlier, the petitioner had also approached the Orissa Administrative Tribunal, which passed an order dated. Where is the date of the? Where is the order of the OAT?
Well, page 21, Annexure 8, man. By order dated 9/1/2008, the learned tribunal
Order dated 9/1/2008 in OA number 1672 of 2007. Directing the opposite party number. Who's OP number 3 there, sir?
Yeah, Collector Dhenkanal, man.
Collector Dhenkanal. To treat the OA itself as an application and pass appropriate orders. So it is stated that despite the above order, nothing has been done by the opposite parties. So Das, you're appearing for whom?
My lord, OP number 1, 2, 3, 4, 5, all 5.
Mr. Das assures the court that if a time-bound direction is issued to examine the petitioner's grievance and pass an appropriate order, it will be complied with. So accordingly, it is directed that the collector Dhenkanal will examine the.
Now it is collector Anugul.
Collector Anugul.
Anugul. Now it will be Anugul. Yes.
Where do you say that you belong to Anugul now?
No, my lord, now after bifurcation, it is coming under district Anugul. But at the time of retirement, it was Anugul Dhenkanal, collector Dhenkanal.
Yes. Lord, before bifurcation, Dhenkanal was the parent district.
Yes.
It is stated that as a result of bifurcation, the matters now be considered by the collector Anugul.
Yes.
Accordingly, a direction is issued to the collector Anugul to examine the petitioner's grievance as set out in the present petition. And after hearing the petitioner, to pass an appropriate reasoned order, not later than 2 July 2022, and communicate with the petitioner not later than 11 July 2022. If aggrieved by such order, to be open to the petitioner to seek appropriate remedies in accordance with law. The court clarifies that it has not expressed any view in the matter.
Supplementary list item number 12.
12, may I please, Your Lordship. This is a public interest litigation, my lord, against the illegal activities of sand quarry, which was leased out to the opposite party number 8, who is extracting more than the specified quantities using the fake transit pass, my lord. And by this way, he has swindled the money without giving any royalty to the government. Your Lordship may see Annexure 4, that is page 77.
All right. The complaint letter of the petitioner shall be examined by
Annexure
the
6.
district collector by the collector and district magistrate Mayurbanj, bracket opposite party number 3, and after issuing notice to the petitioner as well as opposite party number 8, and after giving them a hearing, the reason order should be passed not later than 16th May 2022. The order should be made available to the parties not later than 23rd May 2022. The court clarifies it is not expressed any view. Petition is disposed.
Supplementary list item 13. Supplementary list item number 13.
Also.
Supplementary list item number 14.
14 is also PIL. The representation is pending before the Tahsildar. The land of the DT has been encroached upon by OP number 4.
So the difficulty, madam, is that representation.
Yes,
What is that showed has been delivered.
My lord?
It says received. Okay.
Yes, it has been received.
All right. The petitioner's representation shall be examined by the
Tahsildar Baliguda.
Bracket opposite party number 3, and after issuing notice to petitioner as well as opposite party number 4. And after giving them a hearing, the reasoned order should be passed not later than 16th May 2022, and the order be made available to the parties not later than 23rd May. The court clarifies it is not expressed in the matter. All right.
Supplementary list item number 15.
15, copies have already been served of my learned friend, Mr. Chimanka. So there's no defect. And my humble submission, my lord, if your lordship would kindly turn to page 14, Annex 1. This is an 148 notice issued for the assessment year 13-14 on 30th of March 2021. So
Covered.
similar matters, my lord, similar matters were before your lordship, along sitting with my lord Justice A.K. Mahapatra, my lords,
Ambika.
on 14th. Sorry, my lords?
Oh, 14th of
on 14th of this month.
Ah.
The similar, unfortunately, the order has not been uploaded,
Oh.
but the matter was 4645 of 2022
Okay.
was one of the matters where your lordships have passed similar orders, quashing the notice and
Correct.
further
Following
proceedings.
that Ambika thing.
Sorry, my lords?
Following that earlier judgment.
Ambika and also Karmakar, my lords.
Correct.
So your lordship may permit me to say that WPC 4645 of 2022
Yeah.
is a writ petition which was listed along with the other batch on 14th, where orders have been passed, my lords.
All right. Same order as 4645
4645 of 2022, my lords.
dated 14th March. Right. And then
Yeah,
16th.
no, the approval of the PCIT is some.
No, my lords. My lord, PCIT may have given the sanction, but as your lordship knows, my lords,
30th March means
it's more than 6 years.
Correct.
As per the old act.
Correct.
Lord, may I just pray, my lord, your lordship may pass similar orders to 4645, my lord, 2022.
Yes, yes.
Quashing the notice and further proceedings.
Correct, correct.
And the other item is also the same.
16.
16, my lords. Yeah.
All right.
And that is Annexure 1 at page 14.
All right.
13-14, 30th of March, 2021.
All right. Both these matters.
Much obliged.
Right.
Greatly obliged.
All right.
Well, I am appealing both the cases.
Supplementary list item 17.
Covered by your lordship's order, my lord. I have given the order by the lordship that WPC 35584 by 2021, my lord. This is regarding, my lord, additional fees. Your lordship covered by the.
All right.
Your lordship. My lord, second one I permitted to withdraw, my lord. This is a cancellation of.
Second is not covered.
Same, that's why I am submitting, my lord. Cancellation of NOC.
So 6643, same order. 6645, withdrawn.
My lord. To liberty be granted to file, my lord.
With liberty to file a fresh petition in accordance with law. Disposed of is withdrawn to liberty straightforward. What about 6646?
6645, my lord, that is regarding, my lord, cancellation of NOC.
No, 46.
46, same, my lord, this order.
So 6643 and 6646, same order. 6645, disposed of is withdrawn with liberty.
Deeply applied.
Supplementary list item number 18.
May I please, my lord?
Oh. 2011A. almost a year old, sir. What were you doing so far? Almost 1 year old, the order, impugned order.
Which this order, Your Honor?
The impugned demand is 24th March. Yes, 2021.
I'm challenging here the order passed under section 201 and 201 within bracket 1A, holding the assessee as assessee in default.
More than a year later, sir. This impugned demand is dated 24th March 2021.
Yes, sir.
And you're filing it in March 2022.
My lord.
What's the reason for the delay?
My lord, in fact, they have filed the appeal, but I'm challenging. They have already filed the appeal against the assessment order under section 201. But I'm challenging here the order itself, which lacks jurisdiction.
That you can take it up in the appeal, sir.
Yes, sir.
You can urge that same point in the appeal.
But they may not consider, because there are 5 grounds on which the order can be quashed.
So if they don't accept, you will file a further appeal here.
My lord, I can show one point. Even the order where passed, heavy demand has been created. They have already attached my bank account.
That's a different issue, sir. Against interim orders, you can always, if the tribunal doesn't grant you interim order, you come here. That's a different matter.
But in this case, the appeal is filed before the CIT appeal, which is a faceless.
Whatever, sir. Even CIT appeal.
Faceless, but they are not passing in an order within a year or two. It takes 2, 3, 4 years. And
you file an application saying have an early disposal of CITA's appeal. Even here today, we can pass this order.
My lord, this is a very good case. The five
Every
year
case is excellent case, sir. Not just good case. Every case is an excellent case.
My lord, on the ground of jurisdiction, I challenge those orders. I may kindly be heard. And there are 5 years
So we
involved.
permit you to urge all of this in the appeal.
And there is another ground also. That is because these proceedings started because there was a source taken place on 27th of February 2019. And the Panchanama there doesn't have any incriminating material. Now, to invoking section 201, 201A, there is no jurisdiction by the EO. There is also transfer of jurisdiction by the EO.
Whatever, sir, all these grounds you can urge in the appeal.
But there is a very huge, heavy demand against which I have filed IA. So if that is granted,
This is all an indirect way, sir. You can always seek a stay in even before the CITA.
CIT appeal, my lord, it will take lots of time and my business is stalled. I am not able to do as a business.
So you ask for time-bound disposal of your application for stay by the CITA.
I have already filed a stay before the EO, which has been rejected. And the CIT administration is also going to reject it.
We don't know. Depending on your persuasive ability.
Madam, my only difficulty is the time that I have taken 1 year time. So that I can satisfy.
No, that's not the only difficulty. If their appeal is already pending.
Appeal we have filed before the CIT appeal.
Right.
But
you
because
can ask the CITA to dispose of your appeal expeditiously.
But within that period, other thing can be done. It's an expertise order, 201. During the pendency of the COVID, they have issued notice from Sambalpur. Sambalpur was under lockdown and shutdown. In fact, if you would have got a hearing also, then you could have, the things would have been different. The entire order is expertise, all the orders, 5 years. Today, there is 2 cases posted, 3 is not on the board. So this case can be set aside to the jurisdictional TDS AO, who can consider. In that case also, I will get relief. Everything will go, nothing will sustain. This is expert.
What do you say?
No, my lord. I have obtained instruction with regard to jurisdiction, my lord. The concerned AO who has passed the order, he is the competent authority.
So anyway, you urge it before the CITA, sir. We can ask you to ask the CITA to dispose of your appeal at an early date.
In the meantime, I may be protected so far the demand and the attachment is concerned.
For that, the application is pending. The CITA will consider that.
That my stay application is rejected.
Considering that the petitioners already filed an appeal before the Commissioner of Income Tax Appeals, which is stated to be pending. The court sees no reason why it should entertain a writ petition when all the grounds urged in the writ petition can well be urged before the CITA in the pending appeal. Leaving it open to the petitioner to do so, the court declines to interfere in the present petition at this stage. As regards the prayer for interim relief, it will be open to the petitioner to seek appropriate interim reliefs in the pending appeal before the CITA in accordance with law. The court directs the CITA to dispose of the pending appeals as expeditiously as possible and in any event not later than 2nd September 2020. The court clarifies it has not expressed any view on merits. The writ petition is disposed of in the above terms.
My lord, I may be permitted.
And
My lord,
pending application.
I may be protected so far the demand and attachment. I am not able to do business. They cannot do. They cannot attachment to OD account.
Why did you go before the CITA, sir?
The stay proceeding.
You said you can seek appropriate interim reliefs in the before the CITA.
Can I file for stay? Further read? Can I file for stay?
Sir, no free legal advice. We are not here giving free legal advice. All right.
Supplementary list item number 19.
May it please your lordships, the issue involved in this petition is squarely covered by my lords, my Lord Chief Justice and Justice Patnaik on 15/2/2022. That change of opinion. So we'll kindly see. I'll demonstrate how it is covered.
Is it a fresh matter or after notice?
Fresh.
Then notice has to go, sir.
Yes.
Notice, Mr.
Yes, ma'am. Stay of further proceeding, madam. Pursuant to Annexure
All right. Further
5.
Further proceedings.
Pursuant to Annexure 5 merits.
Pursuant to Annexure 5.
For the assessment of 14-15 merits.
May go on, but no final order shall be passed.
Madam.
Till the next date. Reply be filed within 4 weeks, joined up for the next date. List on 18 July.
18 July?
Yes.
18 July.
Supplementary list item number 20.
To the vast matter, Lord. Here the question of law framed in internal running page 5, whether it is correct in the part of the tribunal to ignore the correct fact and vital clause in the membership agreement to hold the assessee was entitled to show only 45% received on account of sale of time share as revenue received. Lordship, see the order of the tribunal is a composite order. It is clarified in page 36, ITA 121 and 22. It start from paragraph 4, and finding is para 11, 41, page 41. We have considered the rival contention, carefully gone through the order of the authority below, and also the order passed by the CIT appeal for the assessment year 96-97 and 97-98. On the record, we find the assessee company engaged in the business of hoteling and setting up the resort at the different tourist destination. The assessee were undertaking 2 commercial activities in the hotel. The first activity is selling the rooms to derive in the guest of shorter or longer duration according to desire of the guest. The second activity is selling a room to the customer for the span of year to avail by the customers concurrently under a fixed prepaid consolidated selling price. The second activity is popularly known as time share scheme, in which each unit sold to the customer is called a time share time unit and comprised for fixed period of 99 years. The assessee company used to collect the lump sum amount from the assessee customer purchasing a unit from time share. The activity of the selling time share unit and the amount received thereon and the treatment such received as income for the current year vis-a-vis the advance received for another 99 years. In this way, the appellate authority considered to be 45 and 50%. And lastly, page 43, last paragraph, we also find that the bifurcation was as per the industrial norm, as similar procedure is followed in other resort engaged in a time share scheme like Sterling Resort Private Limited. This Sterling Resort Private Limited is having a maximum base in the number of time share members through the country, and the same claim to be industrial, which has been rightly followed by the assessee company. My submission is not others account. Process of account cannot be accepted and cannot be treated to be the accounting procedure of the present assessee, because he has received the altogether amount in assessment year. Year bifurcated is the same.
But he's treating some as advance for the future years.
But he has
not
received
a complete rendition of services in that year, please.
But he has received the amount in the said year.
So what? He's entitled to treat one portion of it as advance.
Correct, Miller. But every assessee has the account is separate. cannot be considered by the adapting the other's account and treating the same procedure by the present assets, I think not, it is not
No,
correct.
if they're in the same,
accounting process,
the
I mean.
same line of business, why not?
Because he is not adapted this type of accounting process. So far as the other which I have placed before your lordship.
No, Sterling Resorts adopts that. So
Yes.
they're only following what is done in Sterling
Yes.
Resorts.
That is the whole issue.
Nothing wrong in this, sir. Some method has to be adopted once it's timeshare system.
Yes.
For many such resorts, a uniform approach is always welcome, sir.
But the accounting process not here so far as these cases contains different as usual in the every earlier years.
No, the whole chain of appeals that you filed, obviously it's a whole series of years.
Yes.
So it's a consistent practice. You say that revenues in filed these appeals. The order of the IT-80 is common, no, to all these assessment years?
Milord, I have 3 files is same to 28, 130, say 130 per. But 73, 70, 85, I have to check the file. I think Milord same, but I have to check the same question, I think.
Yes.
I have to check.
The revenues, the present appeals by the revenue are directed against the common order dated 30th July 2004, passed by the. Oh, first one is 2004. The other is
7, 10, and 11. Other years. Year was 1 year. ITA 161, CTK 201.
But why are you selective about the AYs? 197, 98 alone you have challenged, whereas the impugned order is for 95, 96, 97, 98, 98, 99.
This issue may not be there, but we are confined to ITA 161, CTK 2001.
ITA 228 of 2004 is a revenues appeal against an order dated 30th July 2004, passed by the IT-80. In ITA number 161/CTK 2003 for the assessment year
97-98
paragraph. ITAs 84 and 85 of 2007 are the revenues appeal directed against the common order dated 30th March 2007, passed for the IT-80. In ITA numbers 709 and 710/CTK/2004 for the assessment years 99-2000 and 2000-2001. Then ITA 73 of 2010 is the revenues appeal directed against an order dated 30th July 2010 of the IT-18, ITA number 132/CTK/2008 for the assessment year 2003-04. ITAs 134 and 136 of 2011 are the revenues appeals against an order dated 30th June 2011 of the IT-80 in ITA numbers 93, 94, and 95/CTK/2011 for the AYs 5, 6, 6, 7, and 7, 8. Paragraph. In all these appeals, the question of law sought to be urged by the revenue is regarding the apportioning of timeshare receipts by the SSC as a revenue and capital in the ratio of 45:55%, which has been accepted by the ITA. Paragraph. A consistent reasoning and approach has been followed by the IT-80, not just in the case of the respondent SSC, who has such timeshare arrangements in its resorts, but for other entities engaged in the same line of business, like Messrs. Sterling Resorts, India Limited. As noted by the IT-80's impugned order, open quotation, such apportionment of timeshare sales into 45:55% for revenue recognition is being followed by the leading players engaged in this industry of timeshare sales, unquote. Paragraph. The department's contention was that the 100% of the receipts should be taxed in the year of collection. However, the SSC was under a legal and contractual obligation to provide services for 99 years and not only in the year of receipt. Full stop. As far as the expenses are concerned, it was observed by the ITAT that such expenses had been incurred already, and the SSC was not going to get the benefit of such expenses in future. Open quotation, insofar as the expenses incurred were attributed to the selling/administrative cost and the product cost of the timeshare unit sold. Full stop, unquote. Also, there was no dispute that 1/99th share of the 55% of timeshare receipt was brought to tax in every subsequent year. Full stop. Correspondingly, the SSC was to incur expenditure for maintenance of tourist destinations, etc. Full stop. Paragraph. The court finds that there is a very detailed discussion of the timeshare system in the impugned order of the ITAT. Full stop. The view taken by the ITAT appears to be a plausible one. Full stop. No substantial question of law arises. The appeals are dismissed.
Weekly list passed over matter item number 27.
May I please your lordships? I have challenged the order of the learned Commissioner of Endowments in this writ petition. I have filed a short written note of submission. Your lordship may kindly see. I have filed. Earlier I have filed, it was missed. Just now I have filed. I will just place it for 10 minutes. My lord may see. May I just place it with your lordship's permission?
Yes.
Yes, my lord. The opposite party number 1 filed OA number so and so against the petitioner before the opposite party number 2 in respect of land in Mauja Gautam number unit number 8, plot number so and so, measuring 30 decimals. The grounds in the 25 proceeding are that the case land has been settled in favor of the DT under section 6 and 7 of the OE Act on 3780. Your lordship may kindly mark the date. During the last land settlement, which was finalized in the year 95, the case land has been recorded in favor of the DT. The petitioner is unauthorized occupation of the disputed land The above unauthorized occupation came to the knowledge of the opposite party number 1 finally on 29/96 when field inquiry report was available. Then my written statement. The petitioner with the opposite party number 25 proceeding, after receipt of notice, filed his so called stating that the word unauthorized occupation were inserted by Act 2 of 81 on 2381 amendment in the Act, which is prospective in operation. There is no pleading that the alleged unauthorized occupation was subsequent to the Amendment Act. The settlement of the case land on opposite part number 1 under section 6 and 7 of the OE Act is ab initio void because the case land was in possession of the petitioners prior to 1980 and the said land could not have been settled because section 6 and 7 of the OE Act is not applicable to the case land. Late Banamali Patnaik was in possession of the suit land along with other lands and permission was granted to sanction lease by the then commissioner under section 55 under section 19 of the Act in favor of Banamali Patnaik, who sold the lands to Banambara Patnaik on 30/11/74, and the petitioner purchased the suit land from Banambara Patnaik on 19/9/75. After the purchase of the suit land, with prior permission of Bhubaneswar municipality, the petitioner constructed Pakka compound wall in the suit land with letter and approved plan from the municipality, and the petitioner constructed his residential house on the suit land. After construction of the house, holding tax was assessed and the same is paid from 1981. The petitioner also pleaded that he has acquired title to the case land by adverse possession on proceeding on Section 25 being a summary proceeding. Disputed question of title is not available. Then your Lordship, in order, your Lordship, para 3, your Lordship, skip over, the exhibits are filed, your Lordship, skip over para 3. And para 4, your Lordship, see page 4. After completion of the argument in the 25 proceeding, the petitioner filed written note of submission and memo of citation along with the copy of the judgment. The Land Commissioner of Endowments, without at all considering the pleadings of the parties, without at all considering the documents filed by the petitioner and misinterpreting the points of law, illegally allowed the case. Then my Lordship kindly come to grounds of my challenge. A. The petitioner has specifically pleaded that the word unauthorized possession was inserted by Act 2 of 81 on 2381 amendment, which is prospective in operation. As per decision reported in volume 60 so and so, the documents filed and exhibited on behalf of the petitioner will clearly reveal that the petitioner is in possession of the case land much prior to 2/3/1981, and therefore the commissioner should have dismissed the 25 proceeding on this ground alone. Though the opposite part number 2 in the order in Annexure 9 has come to a finding that the insertion of the word unauthorized occupation is prospective in nature, is acceptable, and admittedly the petitioner is possession of the land much prior to 1980, but the opposite party number 2 erroneously gave a finding that the petitioner is said to be committing a continuous wrong so long as he is in possession unless it is shown that such occupation is with permission. That section 25 of the Act clearly stipulates that in case of any alienation in contravention of section 19 of this Act of section 58 of the OHRE Act 1939, that is old Act, or in case of unauthorized occupation of any immovable property belonging to, endowed, or for the purpose of any religious institution, the commissioner may, after summary inquiry, send requisition to the collector of the district to deliver the possession of the same to the trustee of the institution or a person discharging the function of the said trustee. It is respectfully submitted that in the instant case, as per Annexure 1 to the 25 petition, the only claim of the opposite party number 1 that the petitioner is in unauthorized occupation of the case land. Therefore, the finding of opposite party number 2 that the occupation of the petitioner in the case land is without any permission is clearly an error of law, and therefore the order should be set aside. Then, this is very important. The settlement of the suit land in favor of the opposite party number 1 as per Exhibit 2 is prima facie a void document as per the decision reported in so and so. I will press it later. And though the petitioner is admittedly in possession of the suit land by constructing his residential house much prior to 3790, the kisam of land in the order dated 3780 as per Exhibit 2 is mentioned at Puratana Patita against plot number 2469. Therefore, the opposite party number 1 should have dismissed the case of the Act because opposite party number 1 cannot derive any title in view of the void settlement by the Exhibit 2. It is relevant to mention that the managing trustee of the Lingaraj temple has applied for permission by opposite party number 2 by the Exhibit B on 53, and the opposite party number 2 on 22/5/55 has sanctioned the lease of the land on section 19 by the Exhibit C. The opposite party number 1 with malified motive did not mention this fact in the petition under section 25 of the Act. And the time of argument of the 25 proceeding, opposite party number 1 has taken a plea that the same sanction order has not been acted upon because no lease deed has been executed. It is respectfully submitted that the opposite part number 9, who has a very limited jurisdiction under 25 of the Act, has found that the order in Exhibit C cannot be treated to be permission under Section 19 of the OHRE Act. The said finding is contrary to records, and opposite part number 2 has no jurisdiction in a proceeding on Section 25 of the Act to give a finding that the sanction order passed under Section 19 of the Act by the then Commissioner of Endowments on 22/5/1955, that is 53 years back, cannot be treated to be a permission under Section 19 of the Act. It is relevant to mention that the temple authorities have never challenged the said sanction order dated 22/5/1955 before any higher forum at any time in any manner, and therefore they have deliberately suppressed this fact in the petition under Section 25 of the Act, and therefore the order is liable to be set aside. The finding of the opposite part number 2, this is very interesting, my lord. When I have pleaded the matter, the Honorable Commissioner of Endowment is the superior judicial officer. My lord, see what is the finding he has given. The finding of opposite part number 2 in Annexure 9, the mufasil pleading are not to be strictly construed, as has been held in decision reported in so and so, is not applicable to the facts and circumstances of the present case, because the Court of Commissioner of Endowments, Bhubaneswar, who is presided by an officer of superior judicial service and which is situated in Metro City, Bhubaneswar, cannot be termed as a mufsil court. The petitioner has taken a specific stand on the so cause, and in the oral evidence that he is in possession of the case land since more than 40 years till the date of filing of 25 application, and therefore the petitioner has perfected the title by adverse possession, and therefore the petitioner cannot be evicted in a summary proceeding. It is submitted that the opposite part number 2 has not at all considered the aforesaid submission by the petitioner, and no finding was given by the opposite part number 2 regarding adverse possession. This is then H is also very, very important. The witness on behalf of the opposite part number 1, PW1, in the cross-examination, the last line has clearly stated, it is not a fact that the possession of opposite party is unauthorized. That LCR is there. I will show to your lordship. It is respectfully submitted when the sole witness adduced on behalf of the opposite part number 1 has specifically admitted that the possession of the petitioner is not unauthorized. Opposite part number 2 should have dismissed the 25 proceeding on this ground alone. Though the petitioner in para 4 of the written note of submission at Annexure 7 has clearly stated the above fact, opposite part number 2 did not at all discuss the above submission in the entire order, and therefore the order is liable to be set aside. Then last, the opposite part number 2, while delivering the order in Annexure 9, has not at all considered. Then J is very also relevant. I will show from the petition. It is relevant to mention that OA number 125 of 96 under 25 Act, the schedule of land, you lordship may see. That is also very relevant for this purpose. The petition under OA number 195, the schedule of the land has been described as follows. District Khurda, Tahsil Bhubaneswar, Mauja, so and so, unit at 30 decimals. And it is respectfully submitted that is the specific case of the petitioner that as stated in paragraphs 4 to 8 of the so-called filed by the petitioner before opposite part number 2 by Annexure 2 to the writ petition, the petitioner has purchased 155 decimals of land, including the case land as per the sketch map in the sale deed by Exhibit E. The description in the schedule land stated by Annexure 1 is not sufficient regarding the identity of the suit land because no boundaries have been mentioned in the suit land, and by the order of the Land Commission of Endowments by Annexure 9 is not executable of the 25 proceeding was liable to be dismissed under Order 7, Rule 3 of the Civil Procedure. Now, before going to the order of my lord, my respectful submission before lordship should kindly consider that I have purchased total 155 decimals, including these 30 decimals. I have already constructed my house there. So what, with your, if your lordship will permit me, what I suggest, now this person is around 80 years of old, this person. I don't want to litigate further. I will suggest your lordship may remit the matter to the Commission of Endowments. I will approach the temple authority to settle the land in my favor in whatever terms and conditions, because nowadays they are coming with a uniform policy for settlement of the land who is in long possession. I will approach the authority to settle the land in my favor, because these are, if it will go back, Puni again hearing, then that person cannot litigate. That is my sort thing. Your lordship may direct the, because once this order is not set aside, I will go to the temple authorities. They will say this order is staring at you. So I will approach, your lordship may remand it back to the commissioner. I will approach the temple authority. Commissioner will decide to settle the land, whatever, as per the uniform policy or as per the market price, what your lordship will direct.
You're for the temple.
My lord.
Ah.
My lord, so far as this uniform policy is concerned, we took instruction from the temple administration. They said that there is no such uniform policy coming up, at least in the future also. And it was once discussed, but it failed. As regard to, my lord, this section 25 application under OHRE Act, my submission is that after the order, after it was found that they are in unauthorized position, the remedy for them, the next course of action is that a requisition will be sent to the collector, and if they are aggrieved by the requisition of the action of the collector, a suit lies. That is section 25 subclause 3 says. Now that in the petition and from the circumstances is clear that they are claiming title over the property. Now under section 25, the title cannot be gone into, and if they want to establish the title through adverse position or through any other means, they can simply approach under section 25(3) the civil code, so that the title can be established. Because prior to this, there is one step which has yet come because of the stay of order operating. That is that the collector will start any action as per the requisition of the commissioner. Thereafter, they have the right of going to suit. I'm reading that particular 25(3). Any person aggrieved by the action of the collector may institute a suit in the civil court to establish his right. Now, by this writ petition, they are trying to establish their right in 226 proceeding, my lord. Our only case is that since their case is that they are in possession since 1955, we say that that possession is unauthorized. And from the discussion from the learned commissioner's order, it is clear that from the year 1955, we have also admitted that yes, there was a permission which was sought for lease of the property in the year 1955. But section 19 says that before transferring a property, the management trustee shall take a permission from the commissioner. That permission was taken, but later on it was never effected, because the effect is under section 107 of the TP Act for lease. There is no lease, there is no transfer of the property. Transfer of the enjoyment of the property is not been transferred as per section 107 of the Act. So now they say that just because there was a permission that was initiated, that means they presume that there was a possession later on that they took, that is a permissible possession. But we say that just because they are in possession after 19, that doesn't mean they have possession become a valid possession. It is an unauthorized possession. That is our case, my lord. And they have not shown any document thereafter that whether there is a valid lease which is operating in favor of their vendor. Once they don't establish a clear title which is flowing from their vendor, they cannot say that they have a right over the property. Whether after 1981 or before 1981, the amendment came, they are still in the unauthorized position.
All right.
My lord, in short reply, my lord, regarding suit, your lordship may see, when a requisition is issued by the collector, then a suit will lie. Otherwise, the order of the commissioner is challenged, can be challenged before this honorable court under Article 226, my lord. That is no bar. So far as that particular point claiming title, my lord, your lordship may see, we have purchased the land in the year 74 from the second purchaser. And the land has been settled in favor of the temple in the year 1980, when we are in possession. My lord may kindly see the decision I have filed in the memo of citation. Your lordship may come. The second decision, your lordship may see. These things has not at all been discussed. Your lordship may kindly see that second one, 67, 1989 CLT page 493. Your lordship may come. The second decision, two decisions are there. That is 1988 SCC online. Your lordship got it. The second decision. My lord may come to para 8 with due respect. Admittedly, I am purchased in 74 and it was settled in their favor in 1980, stating that it is Puratana Patidam. Your lordship may kindly come to para 8.
Yes.
It is true that an application has been filed by the ex-intermediary under section 6 and 7 of the OE Act, but on the admitted case, namely that the plaintiff was in possession of the land in question as a tenant and prior to on the date of vesting, the application by the ex-intermediary for settlement would not be maintainable under OE Act, since to act out under section 7, the precondition is that the land in question must be in khas possession of the intermediary. So this is admitted case that on that date we are in possession. All these things have not been considered by the commissioner. And my lord, now regarding the order 7, rule 3 and the evidence of the thing, and these things what my learned friend has argued is not at all in the pleading.
No, this possession is not unauthorized possession, sir.
Yes.
This is an authorized possession.
Yes.
Para 8.
Yes.
Whereas yours is an unauthorized possession.
Yes, that is their claim. No, my submission is when I am in possession of the land should not have been settled in the name of the, when I am in continuing in possession by virtue of sale deed, stating that the
So
land
the
is
sale deed itself is in doubt, sir.
Sir,
your vendor, does he have title to convey the question?
That is in view of that sale deed they have issued, and that is not their case. Your lordship may see the 25 proceeding.
Yes.
Those things, my respectful submission is the commissioner has not at all considered.
Right.
That is my whole endeavor. Lordship may see the order of the commissioner.
Yes.
And regarding that evidence and order 7, rule 3, what has specifically raised, no finding has been given, not at all discussed.
All right. Orders reserved.
Right. I had with your lordship's permission. At the present market value, because totally we have constructed the land. That I am also not objecting. Yes.
All right.
Obliged.
Supplementary list item number 21.
Item 21, my lord, may I be permitted to argue on behalf of Mr. Niranjan?
Yes, yes.
My lord, the petitioner has challenged the taking away of the land of the petitioner in absolute violations of the principles of natural justice in a suo motu revision proceeding initiated.
38B.
Sorry, your Yes, lordship.
38B.
My lord,
38B,
the
yes,
issue has already been settled in the connected matter that is already in the record 14813 of 2009. After a series of litigations, finally the matter was settled in favor of the DT. I am appealing for the DT, my lord.
Right. Let him address it, sir. Let him address.
Grateful, lordship, my lord. Extremely grateful. My lord, what my learned senior is submitting, my lord, that to a point is right. But however, my lord, my case falls at an absolute different footing, your lordship. My lord, may kindly have annexure 1, which starts from page 12, my lord.
Yes.
My lord, this is a suo motu revision. Your lordship will see that all the parties from opposite parties 1 to 14 before the revisional authority, my lord, the petitioner is not named. My lord, may kindly have the petitioner, my lord, the cause title of the writ petition, Sibba Mahakur. My lord, how I derive my title and otherwise, my lord, those are not matters of question at the present, at present, your lordship. Your lordship may thereafter have annexure. Your lordship may thereafter have the subsequent order passed in annexure 2, my lord, at page 32, my lord.
Yes, please.
My lord, serial number 8.
Yes.
My lord, this is me. This property has also been directed to be taken over. Now, your lordship may kindly see the part of the learned member board of revenue at page 28 as to what are the directions that have been issued, your lordship. My lords have it?
Yes, yes.
My lord, para 38, Tahsildar Sonpur shall straight away correct all the last published RORs and tenants ledger of the suit land, acre this and this, 23.991, in favor of Maheshwari Devi Biche Bagduli, Marfat, managing trustees, on the strength of this order, without opening of the any case for further processing or adjudication, because the opportunity of hearing has been given in this case to all the concerned persons. They were all heard also, the suit land shall be recorded exclusively in the favor of the DT without any kind of encumbrance, including possession. No names of any individual, either as the managing trustee or otherwise, shall be recorded in the RORs to be corrected as above. The opposite parties number 2 to 14 have no right to possess the land, nor should they possess the land. The suo motu revision is allowed. Now, your lordship may kindly see who were the parties before the suit in the suit to whom notices were issued by the learned member, Board of Revenue, your lordship. My lord, may kindly have para 9 of the order, my lord, running page 5 of the order and page 16 of the brief.
Yes.
My lord, para 10. The report dated 1/10/2004 of the Tahsildar Sonpur was perused. They had reported that Khedu Dehuri and Sahadev Dehuri both are since dead. They have also been substituted by their surviving legal heirs in this case. The Tahsildar Sonpur in his lengthy report has concluded that Khedu Dehuri and Sahadev Dehuri were in khas possession of the suit land, settled with them respectively as mentioned in paragraph 2 and 3 on the date of vesting of the ex-estate. My lord, never ever have I been noticed in the case, your lordship. My lord, para 13 on the next page, your lordship will see, my lord. On the report of the Tahsildar Sonpur, the court notices were issued to all the opposite parties. The notices number 1 to 14 had entered appearance in the court through their learned advocates. The court notices were sent to opposite parties number 12 to 14 by registered post dated this, seeking their appearance in the court on this. None of the registered letter had returned even after the expiry of the statutory period of 30 days. My lord, and your lordship will see that the property that has been taken away, my lord, all the others were probably contesting before the learned member Board of Revenue, whereas my lord, I have never been issued notice. Your lordship, that is clear from page 32. I was a record of right holder, your lordship, that I have annexed at Annexure 3 at page 34. Your lordship may kindly have a glance at that. In the year 2002, this was issued in my favor. My lord, the final publication, after being done, it was been recorded in my favor. And despite not giving me any notice and with the categorical direction that I have got no remedy left, your lordship, this impugned order has come to pass against me, your lordship.
Yes, please.
My lord, I have never ever been given an opportunity to address my case.
All right. Yes, what do you say?
Yes, my lord. My lord, the background of this is a long history, my lord. Before coming to the present case, my lord, the petitioners in the OJC, the petitioners in the earlier read petition 14813, my lord, they were claiming that the DT in question is a private DT and we are in a cultivating possession, and the so-called we enjoy the land as Sevaiyat, but it's a private DT. And what they did, without imprinting the DT, they filed a case under 6 and 7 under OEA Act in 1976. That was challenged in the Board of Revenue ultimately, and that was allowed by the present DT that the DT should have been made a party. That was challenged in, my lord, read petition by the petitioners, my lord, in that 14813, and that was allowed on the ground that the land has been settled under lease principle and not under the OEA Act. The matter went to Apex Court, my lord. That matter was remanded to this honorable court, and after, my lord, again the matter was heard. And ultimately, the view of the member Board of Revenue was upheld that DT should have been made party, and matter was remanded to the member Board of Revenue to give a finding whether on the date of vesting, the DT was in possession through Sevaiyat or the Sevaiyat in their own as intermediate, they are in possession, my lord. And ultimately, it was held by the member Board of Revenue after the matter was sent to the Tahsildar, and ultimately it was held by the member Board of Revenue that the DT was in possession through Sevaiyat. And another interesting part, my lord, I want to bring your lordship's notice The matter has already been settled by this honorable court upheld I'm giving the, my lord, the judgment of the passed in 14813 of 2009, my lord. I think the record has come.
No, it's there. You've got it.
Your lordship may turn to, and ultimately it was upheld by this the order of the member board of revenue has already been confirmed by this honorable court in 1-4. Both the matters were heard together, my lord, including this matter, my lord. By mistake, that was judgment was passed, but this was left out by mistake, my lord. Your lordship may come to page 15 of the judgment, my lord. There the land is governed by Bhumi Vidhi, that state code at that Sonpur state, my lord, section 13. That is very important, my lord. That is quoted in the judgment, my lord. If your lordship come to Devattor Mafi, the lands in questions are, status of the land is Devattor Mafi, my lord. And if your lordship come to page 16, your lordship may come to page 16. The Seba themselves shall not be entitled to make any partition of the properties among themselves or divide the duties and liabilities of the deity among themselves, my lord. Then your lordship make a subsection A. A Sebayat may allow a member of his family to be in cultivating possession of a portion of the lands under him at his own risk, but the state will not recognize such possession by such a member of the Sebayat family to be enforceable by law. This is very important, my lord. So the records which are in the settlement records, their name were recorded. That was negative by this honorable court, and the order of the member board of revenue was upheld, and the possession of the land was given, my lord. So far, the present petitioner is concerned, my lord. This is also very interesting, my lord. If your lordship come to the paragraph 4 of the writ petition itself, that issue has already been decided, my lord. Let's come to paragraph 4. The earlier writ petition 14813 and this writ petition, if you lordship see,
identical.
Same government, my lord.
All right.
Paragraph 4, my lord.
Right.
The petitioner is the daughter, son of one Parikita Dehuri and son of one Mukta Dehuri, sister of one Kedu Dehuri. And during the commencement of first settlement, the lands allotted for the Seba Puja of Jamidar private deity was recorded in the name of Daman Deuri in Kula Devi Mafi status by Khata number 13 and Bhadralok Mafi status in the name of Saranga Deuri. During the lifetime of the Daman, and after him his sons and others were in cultivating possession and were doing Seva Puja, and the petitioner's mother got the said land, and after him same was received in the name of the petitioner. This issue has already been settled under section 13. Now their only case is that this land belongs to Kedu Deuri. They are the Seva Puja. They were claiming their independent right over the property. That has already been negated by this honorable court, upholding the and upheld the order of the member board of revenue, my lord. Now, my lord, his only case that his source of getting this land is from that Deuri. And section 13 is very clear. They may allow, he has no enforceable right over that. Now, my lord, actually what happened in this case, when though no order of stay was passed in the earlier case, immediately this was filed, claiming that my name was not there and the land is recorded in my name in the settlement ROR. That doesn't create any right. And he himself admits the source. It is from the Deuri family. And they were enjoying the land as Sebak, that Mafi land. So they don't have any right over this property. And this is their, and rightly, after judgment of this honorable court, the land has already been recorded and already been delivered. And it's a public duty under the administration of the direct administration of the Commission of Endowment, my lord. And my humble submission is that in such a situation, can he take advantage? The question which I put to myself, my lord, can he take advantage that my name was, though I am a recorded tenant, my name is not there. Therefore, I should have been given an opportunity. When there is a series of litigations and the document clearly shows that his source. Let him say from where he got independently. And he has not filed any document except that ROR. And he admits that it is from Dehuri.
All right.
Sorry,
Yes,
if I may
Mr.
please,
Mantri.
my
You
lord.
have to say something.
My lord, I am to the opposite party. The so motor revision case. One thing has happened. What has happened? This Dehuri family, it's a Semayat family. There was substantial representation in the revision. Family members were there. One left out, and he is saying that no opportunity was given. But so far as the land, it is a big chunk of land, and the petitioner is concerned, as per the ROR, is concerned with only 800 decimal of land. There was series of litigation. Everything has been settled. His source from whom he has allegedly or purportedly acquired the property, his case has already been decided. So there is nothing to interfere with after this because land has already been given to DT and property has already been recorded in favor of the DT for long.
All right.
May I give a short reply with your lordship's permission, my lord?
Yes, please. Yes, please.
My lord, I might lose your lordship, my lord, once given an opportunity of hearing. The very principles of natural justice have not been followed. My lord, I'll just straight away take your lordship to page 17, my lord. My lord, what could have been my case otherwise? Your lordship, may please have page 17 of the brief. From where the entire right, title and interest flows, your lordship. My lord, this is with me, with arguendo submissions that considering that the learned member has rightly passed the order, your lordship may kindly have page 17. My lord, have it?
Yes, please.
My lord, will see the first land schedule that is given, ROR published in 1907. Your lordship may kindly mark the total area which they allege to have been in the name of the DT, which is written in the upper paragraph. The suit land in the first settlement 1907 ROR were recorded as scheduled below on Devatwa Mafi status in the name of Daman Dehuri, son of Ganga Dehuri, in possession. At the end of ROR, while totaling the extent of the land recorded, Kula Devatwa Mafir Moat has been mentioned. The mention of Kula Devatwa Mafir Moat is the loose representation of the status of Devatwa Mafi, which has been mentioned in the appropriate column in the published ROR. There is no mention of Barkali Zamindar in the first settlement ROR and also in any of the subsequent published RORs. My lord, the total area, your lordship may kindly mark, my lord. My lord, it is 22.39 acres that is in question here, your lordship. My lord, in the subsequent settlement, my lord, it suddenly becomes 24.18. In the next settlement, it is 24.11. And thereafter, in the next page, your lordship will see that the ROR calculation 1963 is 23.991 acres that they are concerned with, your lordship. However, your lordships will see that the land that has been taken away is in excess of 23. My lord, may kindly have page 32. My lord, the order starts from page 29, my lord. These consequential orders that were passed. My lord, the land schedule starts from page 30. My lord, holding number 88, total area 13.023. Next page, your lordship, total area acre 10.968. Acre total 23.991. So this is the total area of land schedule that was supposed to be taken in pursuance to the orders which I have read to your lordships at page 28, your lordship. They have categorically mentioned that this Tahsildar shall straightaway correct all the last published RORs and tenants ledger of the suit land, measuring a total of acre 23.991. Now, your lordship, the total calculation that comes down in the next page, which starts from page 31, which the current settlement, your lordship will see Mauza Bagduli, PS Sonpur, PS 43, Khata number 28. The plots number have been mentioned along with the Khata numbers, and all these total plots do not constitute 23.991. In the alternative, my lord, the total lands that have been taken away is 24.149, your lordship. Your lordship may kindly visualize that, my lord.
All right.
And my lord, no opportunity of hearing has ever been given to me, my lord, despite, my lord, I might lose the case. They have calculated me, they have found my ROR, but they have not even issued me notice. My lord, it is not a case that notice was issued to me and it has returned as insufficient. The suo motu revisional authority, under its statutory powers, although initiating a suo motu revision, ought to have bare minimum issued me a notice, my lord. That, my lord, has never been done. My lord, the entire principle of natural justice, my lord, I may fail in the case, my lord. I do not dispute that. But my lord, the basis of this judgment is against me, my lord. The order which my learned senior was referring to, which has been already upheld, which has already upheld the judgment which was passed in the lower court. My lord, that I was never a party. I was neither a party then, your lordship. My lord, I came to know about these orders in 2009 because never since the earlier proceedings, whether before the Honorable High Court in 1992 or before the Honorable Apex Court, my lord, I was never a party, your lordship. I have never gone to the Supreme Court, your lordship. I came to know about this order against me only in the year 2009 and immediately I filed the present writ application challenging the very action taken by the member board of revenue without even noticing me, giving me a fair opportunity of hearing your lordship.
All right. Order is reserved.
Grateful, your lordship.
Supplementary list item number 22.
That appears dismissed on discussion.
Supplementary list item number 23.
23, I pray for Passover.
Supplementary list item number 24.
Item 24, my lord. This is a writ application challenging the complete inaction on the part of LIC authority, thereby not constituting the internal complaint committee for sexual harassment as per the Visaga guideline, man.
expired. It was valid for 1 year.
In the select list,
Within
the select
1 year,
list
after 3 months of the merit list and appointment, they published another advertisement.
not infructuous. By passage of time, the subject matter of the present petition has been rendered infructuous. The petition is disposed of. Yes.
Supplementary list item number 30.
None appears dismissed or non-prosecution.
My experience.
Supplementary list item 31.
I'm for the petitioner. I'm questioning the academic and nonchalant approach of the.
Please speak into the mic, sir.
Yes, my lord. We are questioning the academic and nonchalant approach of the.
Kindly take off your mask and speak into the mic, sir.
Lordship. Sadhu. Yes, my lord. Lord, they questioning the lackadaisical nonchalant approach of the state authorities for not enlisting the boxing as a sports, my lord. In discipline that one of the writ petition was filed. The lordship, lordship by virtue of last order, the 10/2/22, lordship directed to file an affidavit disclosing the names of the persons who are interested in pursuing the boxing as a sports, my lord. And accordingly, my lord, I filed an affidavit disclosing the names. Now that is not on the board.
So where is that affidavit?
I filed.
Unable to proceed meaning what?
My lord?
In para 5, you say they are unable to proceed. Proceed meaning what?
Proceed, my lord. We have collected data of some, my lord.
No, what do you mean by they are unable to proceed? You say they have successfully participated in district level, state level, national level championship, secured different positions, but they're unable to proceed. I don't understand. If they say participate in all these championship, where should they proceed?
They are not, my lord. The selection, my lord, is based through talent scout program, which is conducted in each and every year. That is not.
Sir, I'm talking about your para 5.
Yes, ma'am.
You have your affidavit?
Yes, ma'am.
Just come to para 5. You've given 15 names, correct?
Yes, my lord.
And what have you written after that?
Yes, my lord. That page 3, my lord. Lordship referring page 3. Yes, my lord. And my lord, they have been participating in the district and state level, but they are not getting that adequate training which is required to, my lord, required for at least in a higher level.
That is all depends on individuals, sir.
No,
everybody can't be a champion.
My lord. She wanted to know whether there are students
who are appearing for the state.
Yes, I am appearing for the state plus. Here, the principal prayer of the petitioner is that as to why the vacant seats of boxing discipline in the sports hostel shall not be filled up immediately. Plus to that, we have filed one reply to rejoinder that is on 21st October 2019. And they are on record laws. I just want to bring to Lordship's kind attention the page 3 of that affidavit. That itself says, was the last paragraph I'm reading, that during normal talent scouting process in the subsequent years, no players became eligible for the boxing discipline as per selection criteria.
Once.
Lordship got it?
Have you seen that?
Then the reply filed by the opposite party in reply to the rejoinder filed by the petitioner, dated 21st October 2019.
Yes. Yes, please.
They want vacant seats of boxing discipline in the sports hostel. Why it shall not be filled up? That is the primary clause prayer. There I am reading the last paragraph, page 3 of that affidavit. During normal talent scouting process in the subsequent years, no players became eligible for the boxing discipline as per selection criteria. Since the allotted seat of boxing could not be filled up due to non-availability of deserving talents, after careful considerations, Sports and Youth Sports Department have been pleased to reallot the student strength of sports hostel of the state with other discipline. Right, Office Order so and so.
Mr. Katke, so after reading this affidavit last time that we passed the order.
My lord.
So now he has filed an affidavit giving names of 15 persons who are interested.
No, that I have to get a response.
You find out, you take instructions. You say an additional affidavit has been filed by the petitioner, a copy of which is available with Mr. Katkia, setting out the names of 15 persons who, according to the petitioner, are interested in pursuing the sport. Mr. Katkia states, full stop, a further grievance is made that boxing is not included in the talent scout program. On both these aspects, Mr. Katkia needs time to take instructions. List on 29th June.
Supplementary list item 32.
So obliged.
May I please? My lord, I will continue. Item number 30. Just I was sitting outside. By the time I entered, it has been 31.
Tell us what it is. Kindly tell us, please.
My lord, item 32, my lord.
1 minute, sir. Kindly hold on just for 2 minutes.
Yes.
My lord, it's a public interest litigation.
Yes.
The matter is relating to construction of a subway that is of very low height. Actually, the existing manned level crossing, they have decided to stop it. And subsequently, matter was taken up before your lordship earlier, and there was a discussion, and they assured that they will reschedule their the road so that the existing crossing, railway crossing would be stopped. And they have to give that instruction, some information to the court. In the meantime, we have got some information that is information. We have received a letter on 18/12/2017 that with the 50-50 partnership, that is the state government as well as the railway department, they will construct. And the existing the railway crossing is still functioning.
Then the second petition is infractuous. You said 2524-546 of 2017. Since according to counsel to the petitioner, the railway crossing in question is still functioning, the present petition is infractuous and is disposed of as such. In 25117, they've already got a plan.
Yes, my lord.
For construction.
Yes, my lord.
So
accordingly, they have given an intimation, but the question is that they have not given that intimation to this honorable court. For that reason, the matter is dragging on.
Let it not drag on, sir.
They have given a letter.
Show us the letter.
I am just supplying the letters. Both the letters. This is one letter and this is another. Another letter. Another copy.
All right. From the letters dated 18 December 2017 and 4 January 2018 of the East Coast Railway, copies of which have been placed before the court by the counsel of the petitioner. It appears that responding to the demands of the petitioners, steps are being taken for construction of a ROB and RUB on 50:50 cost sharing basis. That view of the matter, no further directions are called for. Petitions disposed of.
Supplementary item 32.
May I please, my lord? My lord, on 29/4/2021, your lordship, the government state, my lord, prayed for time to file additional affidavit pursuant to my petition and additional affidavit. If your lordship permit me, I will place the matter. They have not filed any affidavit.
Your lordship, I can take up the matter.
Right, sir.
My lord, your petitioner, my lord, in this writ petition, prayed for a direction to promote him to the post of Siresdar on the judgeship of the Khordha, my lord, with effect from 1/9/16, my lord. My lord, the case is, my lord, in the year 2016, the petitioner is the second senior most grade 1 bench clerk, my lord, under the judgeship of Khordha, my lord. In the first part of the 2016,
We'll take it at the end of the board, sir. Take it at the end of the board. All right.
Supplementary list item number 33.
May I please, my lord? The last occasion, 18th January 2022, this honorable court directed the London Senior Standing Council at para 5 to produce the annexure 6, whether part of the record or not.
Yes, my lord. I have the record, my lord. It is found, my lord, lordship has directed to verify whether the annexure 6 filed in the writ petition, my lord, that is available in the record or not, my lord. That is, I find, my lord, that is on record. And that has been taken into consideration in the 264 order, my lord.
How?
My lord, that is mentioned in the 264 order.
Let's see that.
Yes,
where is it mentioned?
Lordship, kindly have a glance. My lord, lordship, kindly have a glance to page 16. There, my lord, in response the NLA Agrawal FCA and the AR of the SSC appeared on 14/2/2000 and relied on the petition. On request, the case was adjourned to 5.
Which para are you reading, sir? Which para number are you reading?
Paragraph 3, my lord. Sorry, my lord. Paragraph 3.
That's page 15. Anyway, 16. It's all right. Para 3.
My lord, paragraph 3.
No, this is not the way of dealing with this annexure 6.
Thereafter, it has been, in the next paragraph, it has been mentioned, my lord, this statement, which was produced as annexure 6, my lord, 24th February 2020, that was produced for the commissioner. My lord, he had made an inquiry through, my lord, the assistant commissioner, my lord, which was found. Lordship, kindly have a glance to annexure 6.
Where does the order deal with what he is seeing what he is saying in annexure 6? That's the point.
Yes, my lord. He has mentioned here, my lord, in paragraph page 17, paragraph 6. Paragraph 6, my lord, in the impugned order. Then, my lord, appeared and he failed to furnish the required detailed supporting documents.
This is the whole annexure 6, sir. Instead of dealing with annexure 6, he's going on saying he's failed to furnish documents.
Yes, my lord. Because annexure 6, my lord, only a chart without having any document. Again, my lord, what was submitted before the assessing officer, that was again submitted.
Show us annexure 6. What is annexure 6? Show us.
Annexure 6, my lord, only the document
My
he
lord,
had submitted,
that is also
the data sheet.
Show us annexure 6, sir. Just send him and get the file. Send him.
Just 38.
He has got a file with him.
Yes, ma'am.
Ask him to get the file from that person.
Here, my lord, question is, my lord, giving advances to the subordinate banks.
Sir,
rural
I think
banks.
you're not being correct in your submission.
My lord, these
Unless my arithmetic or counting is very poor, I don't see this as a single sheet. When I asked you just now about Annexure 6, you said it's a single sheet, correct?
Annexure 6 series, my lord, he has submitted. He has submitted Annexure 6 series, which are the.
When I asked you Annexure 6, you said it is a single sheet.
No, my lord. Sorry, my lord. Sorry, my lord. Annexure 6, my lord, he has, along with that is the forwarding letter your lordship getting. That is the first page of that. And documents, my lord, which
there
the
are
data
documents of 6 pages of documents, sir.
Yes, my lord. That is the data sheet he has submitted, but giving rural advances to.
Where is this discussed in the impugned order is what I'm asking you repeatedly. The impugned order seems to say he submitted nothing.
That is, my lord, only in whatever he has mentioned in para 6. That is.
You say the original record has been perused by the court. Annexure 6 in the original record is a written submission given by the petitioner SSC to the Principal Commissioner of Income Tax. Apart from a covering letter, there are 5 pages of documents. Full stop. The court finds that there is no discussion of these documents in the impugned order of the CIT. On the other hand, it is stated in para 6 that, open quotation, the AR of the SSC had appeared for the hearing, but had failed to furnish all the required details and supporting documents, unquote. Clearly, this statement is contrary to the record. On this ground, the impugned order of the CIT is hereby set aside, and the matter is remanded to the CIT for a fresh decision after hearing the petitioner, to be issued not later than 4th July 2022. The decision will be rendered after hearing, the order will be passed after hearing the petition. The original record has been returned to the Standing Council to be again returned to the CIT for proceeding in accordance with law. The petitioner for the above purpose will appear before the CIT on 4th April 2022 at 11 a.m. All right.
Item 34, same, my lord. Assessment is different.
Next one, same.
Same.
The record is there.
All right. Same order for the next one also.
Supplementary list item 35.
My lord, so far as item number 35 is concerned, on account of my ailment, I am unable to address your lordship today. Kindly call it on 21st.
Kindly permit?
Kindly call it on 21st. Monday.
This is the same matter.
Same matter, your lordship. I'll take only 2 minutes. Subject. Similar matter, refund notice.
Correct.
There are 12 awardees.
Right.
All preferred writ applications before your lordship.
Right.
And your lordship pass common order that you approve for compliance of natural justice. You appear before the collector. Collector will hear the matter and pass necessary orders. Collector had everybody, all the awardees. Order was passed. Common order was passed. All the other awardees deposited the refunded amount. So far as the petitioner is concerned, he has deposited almost 50% by order of this court. And this is so far as my instruction is concerned, I don't know whether my learned senior will agree or not. His clients also, just 3 days back, met the collector and assured the collector that we will deposit the entire amount. This is the government revenue, which has been paid to them due to some clerical and arithmetical error. They have given the undertaking in shape of indemnity bond, that is Annexure A by 2 of my counter affidavit, that if any excess amount is paid, we will repay it. And they have repaid 50% of amount. Then what is there to and another thing also I would like to submit before your lordship, that so far as section 64 application of my learned seniors client, that is already referred to R&R court. That court will decide the exact value which is to be paid, award amount which is to be paid.
Correct.
Even if they refund the amount, they are not prejudiced. That is
Correct.
my responsibility.
Correct.
They are not prejudiced.
Correct.
Because R&R authority, if they say that the amount which we had paid, that is correct amount, we are bound to repay it in further. But now, as per the calculation, if all the awardees have refunded the amount and only one it is left out, that is the petitioners, and your case is now sub judice before the R&R authority. R&R authority is going to decide that what is the exact amount. If at all the R&R authority will come to a conclusion, no, what amount the earlier the collector has paid, that is the correct amount, we are bound to pay it. But so far as this calculation on the basis of which other awardees have already refunded, it is not justified or prudent on the part of my learned seniors clients to retain the amount anymore, because in March 31st, your lordship may kindly imagine, I have no objection if my learned senior on the health issue takes the time, I cannot object it necessarily, but this is the only.
No, but let the amount come back.
Yes, let the amount come back, because he is not a prejudice. Because
how much more have they to pay?
My lord?
How much more have they to pay back?
1 crore something, 1 crore, 16 lakhs, 1 crore 16 lakhs. They have already refunded 76 lakhs, only 1 crore 16 lakhs. Total amount is 1.92.
Yes, sir. So what is preventing them from depositing this 1 crore 16 lakhs?
Whatever amount was received as award, compensation, that has been invested by the petitioners in another business, mining business.
They have to find the amount, sir.
Whatever amount was left with them.
They have to find that amount and give it back.
That's right.
This
That's
submission
right.
was made by my learned senior at the first instance.
Correct.
And when your lordship has directed to deposit 76 lakhs, within no time they have deposited it.
Submission.
They are not such a small businessman that they cannot deposit this much of amount.
Submission to your lordship is that first of all, by common order, petitioner's case was not covered. By a separate order of your lordship, dated 10/8, it was referred to the collector to dispose of my objection dated 26/5.
No, by common order, collector disposed of similar order passed for other awardees.
You have made your submission.
No, you have not heard it properly. That is why, with due respect, I am submitting.
By order of your lordship, dated 10/8, your lordship directed the collector to hear my objection dated 26/5 and dispose it of. 16/8/21, the matter was heard by collector. On that date, the order has been passed, confirming, separate order, confirming the refund notice dated 4/5/21. I have challenged that, according to me, in the writ application, that is not refundable. If your lordship do not agree with my contention in the writ petition.
Sir, you've been given a very long rope, sir.
My lord.
What immovable properties do you have now? We'll attach that. We'll ask for the.
Yes, that
we'll
may
permit
be
them. What is the immovable property you have?
Immovable?
Yes, we'll have that attached, sir. I think you're taking the court for granted now.
I will give a list on 21st.
No. You don't choose the date, sir. The court will choose the date.
That's right.
Don't choose the date. Your client is already in default. Have you seen the number of orders passed?
In order to
have you seen the number of orders passed?
My lord.
Have you seen how many orders have been passed in this case?
Yes, my lord. I have seen. I am the conducting lawyer, my lord.
Don't take the court for granted. And this is not addressed to you, Mr. Counsel. It is addressed to your client.
That's right, my lord.
Don't take it for granted. And if your client wants to address the court in this tone, your client is in for trouble.
That's right, my lord.
Yes.
Give me time to ask my client
we have given you enough time. We've given you a very long rope.
My lord,
we have given you a very long rope. Please read the orders now, one after the other. Read the order dated 9th November. There is a limit to everything. Just read the order dated 9th November.
I am asking your lordship.
You first address the court on what your client is supposed to do.
Yes, my lord.
Come to the 9th November order.
26315.
On 9/11, IA number 15078 of 2021 was before your lordship.
Para 3, read it.
Para 3.
Read para 3, sir.
This application has been filed by
Para 3.
Paragraph 3. As a last chance, time is extended till 6th of December 2021 to make deposit of the balance amount with the government itself, subject to the condition that if the petitioners ultimately succeed, the said amount shall be refunded to the petitioner with interest as may be directed by the court. The application is disposed of.
Now come to the next order, 13th November, 13th December.
Despite this court categorically stating in their order dated 9th November 2021 that as a last chance, time is extended till 6th of December 2021 to make deposit of the balance amount with the government itself, subject to the condition that if the petitioners ultimately succeed, the said amount shall be refunded to the petitioners with interest as may be directed by the court. But the petitioners failed to adhere to the above order. They have now filed this application seeking further extension of time for 4 months to make such deposit. The reason cited therein is that because of freezing of the accounts by the bank of the petitioners, they are unable to pay such a huge amount and accordingly seek further time to arrange funds. It was within the knowledge of the petitioners even when the order was passed by this court on 9th November 2021, 21, it correctly 2011 is that the deadline for making the deposit was going to end on 6th December 2021. The present application was filed on 11th November 2021.
11th December.
Yes, my lord. After the deadline expired on 6th December 2021, the court is therefore not convinced by the explanation offered and is not inclined to grant any further extension of time. The IA is dismissed. As a result of rejection of the IA, the interim order passed to the effect that if the petitioner ultimately succeed, the said amount shall be refunded to them with interest is hereby vacated. Then, my lord, this writ petition.
Nothing remains. I think we'll dismiss this writ petition with exemplary costs. We'll also initiate suo motu contempt proceedings. That's the only way to do things.
My lord, my
it's
only
unfortunate. Just take down. It is unfortunate that this court, that the petitioners have taken this court for granted in the manner in which it will be described hereinafter. Full stop. Excess amount was paid by the collector to the petitioners in the sum of rupees 192,47,082. And when an attempt was made to recover this excess amount paid, the present petition was filed. Full stop. On 2nd September 2021, counsel for the petitioners on instructions informed the court that while they had deposited rupees 76 lakhs that they would deposit 76 lakhs on or before 4th September 2021 in the form of fixed deposit receipt in the name of the collector, and he needed 6 weeks time to make the balance payment. The court made it clear that the sooner the petitioners are able to make the balance payment, it could consider lifting the attachment of their bank accounts, which had been ordered by the collector. Paragraph. After the deadline expired, an application was filed seeking extension of time to deposit the balance amount by an order dated 9th November 2021. Time was extended till 6th December 2021 as a single court's last chance, unquote. It was made clear that all the payments made by the petitioners would be subject to the condition that if the petitioners ultimately succeeded, the amount would be refunded to the petitioners with interest as may be directed by the court. Paragraph. After the second deadline expired on 6 December 2021, another application being IA number 15078 of 2021 was filed on 11th December 2021, seeking further extension of time. Full stop. On 13 December 2021, this application was dismissed and the earlier interim order making the payments conditional was vacated. Full stop. Today, when the matter is listed, again, the same situation has continued. The balance amount has not yet been paid. Full stop. The court is therefore constrained to observe that the petitioners have, despite being given a long rope, failed to stand by their assurances to the court. Full stop. In view of the conduct of the petitioners, the court considers it appropriate to dismiss the writ petition. Full stop. At the same time, the court initiates suo motu contempt proceedings against the petitioners. A notice will issue to each of the four petitioners, requiring them to appear before this court in person to explain why they should not be proceeded against for willfully disobeying the assurances given by them to this court regarding payment of the balance sum, as was undertaken by each of them. Stop. You will accept notice. What is your
better to send to the client petitioner?
We'll have it served through whom? Through special messenger.
Police, local police.
To the
or the notices be served through a special messenger, and if the special messenger is unable to do so, then through the local to the SHO of the local police station, IIC of the local police station, making it returnable on 4th April 2022. It will be open to the petitioners to file their individual affidavits. The registry is directed to register this as a suo motu contempt proceedings. The registry is directed to register this contempt petition. Each of the petitioners is permitted to file an affidavit in response to the show cause notice, in which they will indicate the complete list of movable and immovable properties in their possession. List on 4th April. 4th April, sir.
My lord, may direct that instead of local IIC, DCP may be directed because his house is at Chowdiaganj. Again, another address is at.
All right. Through the DCP. All right.
DCP Cuttack.
Cuttack. All right.
Supplementary list item number 36. Item 36.
But here, the opposite party also to file the counter. They have not yet filed the counter. This is in nature of public interest litigation, whereas the director. Yes.
Yes, sir.
By the annexure 6, the report has given by the deputy director come food analysis that the low quality of the chotto has been provided. Considering this, the report by the annexure 6, my lord also directed the state to file the counter till today.
My lord, this is the past date.
No, this is not first date. Twice, thrice this matter has
come. Another date may be because I have to obtain instruction and file the counter.
No, to file the counter.
It's only come once after notice.
This is also, your lordship will find regarding mismanagement of government funds by way of unholy alliance with so and so SSG groups. This type of cases your lordship is sending to Lokayuk for.
No, this is regarding the report.
minute,
Quality, the annexor 6, the deputy, that is your officer has given that report, not by us. Deputy director,
All right.
come food
At the request
analysis.
of Mr. Mohanty, learned AG, who seeks some more time. Oh, you just say, Mr. Mohanty, learned AG, seeks and is granted 4 weeks' time is the last opportunity to file replies on behalf of opposite parties 1 to 7 and 9.
1, 2.
What about 8 has been served?
I am appealing to open number. Grant Lord some time.
OP number 8 will also file its reply positively within 4 weeks from today, rejoined up for the next date. Just on 22nd June. Sir.
Supplementary list item 37.
May I please, my lords? The noting says that the counter has filed with the opposite party number 2. Opposite parties, my lord. 1, 2, 3, and 4 is not there on record, my lord. And may be permitted to give 2 copies which I have received from them. So your lordship may kindly take note of that. Here, my lord, sir. This is a counter filed by the opposite parties. My humble submission, my lords, is that no notice was ever served on me, my lords. 2, my lords, the failure to serve a notice makes it vulnerable under the new provisions because a draft assessment order has also not been given, my lords. At this juncture, my lord, may I just take your lordships to page 15, paragraph 6.3, my lords, or more specifically, page 16, paragraph 6.3.2, my lords, of the brief, my lords, writ petition. Lordship got it, please?
1 minute.
Sorry. Sorry,
para 6 point?
Paragraph 6.3.2 at page 16. Minutes. Page 16.
Yes.
There, your lordship would only, I'll not take your lordship to the entire paragraph. Your lordship may only note my email address. Minutes. It is mmeconsult@yahoo.com.
Right.
Then, my lords, I'll straight away take your lordship's, my lord, to the counter which my learned senior friend has filed, minutes. And
consultancy.
My lords.
But the copy is to MME Consult.
No, my lords, your lordship would see to consultancy@yahoo.com.
Yeah, but copy,
my lord, becomes a spam, my lords, as your lordship knows, my lords. They have consistently said that consultancy@yahoo.com is the email address in which I have sent it, my lords. I was checking their portals, my lord. In that portal, my lords, if your lordship would permit me, I've prepared 2 copies, my lord, from the portal. My portal address, my lord, is what I've averred in paragraph 6.3.2, my lords. This is from the portal of the Income Tax Department, my lords. And they consistently, the lordship would take up the portal, my lords. At the left-hand column, my telephone number is there, my lord, mobile number, and the email address, my lords. In this case, my lords,
on their portal, your email address is this.
Sorry, my lords?
On their portal, your email address is this.
My lords.
Right.
So in spite of that fact, my lord, they send it to a wrong email address, my lords. They say that the notices have been sufficient. My specific averment before your lordship, my lord, is I have not received notice except the last one, which was received by hand, my lords. The lordship would kindly turn, my lords, to the notices which have been issued at Annexure 4, beginning from page 83, my lords.
Yes.
So if they're so much confident about their email address, my lords, they should have sent this also by email, my lord. But they chose to send it by hand, my lords. 83, page 83, your lordship would see, my lords. This comes to me. I'm sorry, page 71. I stand corrected, my lords. This comes to me, my lord, on the evening of 27th. And this is received by me from a person from the department. And enclosing all those notices, which I have annexed, my lord, which were stated in the counter to have been served on me.
All right. Yes.
And the second point, my lord, is these notices have not been sent in the right email address, my lords. No draft assessments has been given to me, which is one of the requirements of 148 my lords. And so far as the draft assessment orders are concerned, your lordships have already dealt with a similar issue, my lords. Dealing with the other high courts, your lordships have held that since draft assessment is not there, the entire proceeding becomes non-essential, my lords. And this was in another case, your lordship. This was also a challenge relating to non-issue of
assessment.
Sorry,
faceless assessment.
Faceless assessment. This 144B, my lord, deals with a situation, my lord, where a lot of opportunities is to be given to comply with natural justice, my lords.
Yes, Mr. Chimanka.
Yes, para 6 is clear. This judgment is clear.
Para
29279201.
There's an order which I have given.
You have given.
I was only praying, my lord, your lordship may kindly note my contention about the wrong email address. And
so it'll have to, they can have a fresh proceeding.
My lords, and I have just only small prayer, my lord. In the rejoinder, I have taken a ground that this 143.3 proceeding itself is void because this was a set-aside order under 1 or 263 or by the Commissioner of. So 150 should have been the correct section in which should have been initiated, because there in 150, my lord, again the question of limitation comes. So your lordship may leave that point, my lord, to be canvassed before the authorities, my lord, regarding the applicability of 143.3 proceeding, my lords, in view of section 150, my lords.
Right.
And your lordships have already noted that a personal hearing to be given, my lord.
Right.
At paragraph 6, your lordship has said.
Correct.
About a personal hearing also.
All right. Where is your rejoinder?
My lord, my rejoinder, my lord, is that flag C. Unfortunately,
yes, it's there. It's there.
The rejoinder is on record, but unfortunately, there's some.
All right. The present petition challenges an assessment order dated 30th September 2021. Passed by the National Faceless Assessment Center, bracket NFAC, under section 143, bracket 3, read with section 263 and 144, capital B of the Income Tax Act 1961, for the assessment year, bracket AY, 2015-16. While directing notice to issue in the present petition on 16th December 2021, this court restrained the respondents from opposite parties from taking any coercive steps against the petitioner to the next date. Paragraph. The petitioner is a partnership firm engaged primarily in the business of real estate development and construction activities. Full stop. The main source of income is from construction of properties. This is also its main source of income. Full stop. Paragraph. For AY 2015-16, the petitioner filed its return on 1st January 2016. Full stop. The return was picked up for scrutiny.
It was for a limited scrutiny.
Yeah, picked up for limited scrutiny. All right. An assessment order was passed by the assessing officer, bracket AO, on 4th July 2017 under section 143, bracket 3 of the Act, accepting the returned income as declared by the petitioner. Paragraph. On 6th September 2019, a show cause notice was issued under section 263 of the Act by the Principal Commissioner of Income Tax, Cuttack, PCIT, opining that the assessment order was erroneous and prejudicial to the interests of the revenue. The petitioner submitted its objection to the SCN on 15th November 2019. By an order dated 17th March 2020, the PCIT completed the revision proceeding, set aside the assessment order, and directed the AO to examine the identity and creditworthiness of creditors under section 68 of the Act and frame a fresh assessment order. The petitioner states that the appeal filed by it against the above order, being ITA number 151/CTK/2020, is pending before the Income Tax Appellate Tribunal, Cuttack, IT8. According to the petitioner, while the matter stood thus, on 27 September 2021, it was served with a notice by hand at its registered office, granting the petitioner a final opportunity to furnish a reply in response to the notices sent to it by the NFAC for AY 2015-16. Full stop. On the very next day, when on receipt of this aforementioned notice, the petitioner is stated to have logged on to the income tax portal and found that notices were appearing under the single quotes e-proceedings tab, which stated that notices had been issued on 13th August, 8th September, and 23rd September 2021, pursuant to the order passed by the PCIT under section 263 of the Act on 17th March 2020. The petitioner contends that none of the above notices had been received by it, either at its postal address or via email. A reference has been made to the details of the petitioners available on the income tax portal that shows the petitioner's email address to be mmeconsult@yahoo.com. The petitioner further states that on searching the portal, it could not find any of the above notices. On the next date, that is 28th September 2021, it submitted an objection stating that it had not received any of the notices. The petitioner sought a personal hearing and for some more time to make a detailed submission. It is stated that notwithstanding the request, the impugned assessment order dated 30th September 2021 was passed, followed by a notice of demand dated 8 November 2021 and a penalty notice dated 30th September 2021. Paragraph. The two principal grounds on which the impugned assessment order is challenged is that it is in violation of the principles of natural justice, since none of the notices stated to have been issued to the petitioner were in fact received by it. And secondly, that in terms of section 144 capital B of the Act, it is mandatory. It's a mandatory requirement of faceless assessment to have a draft assessment order passed initially before passing the final assessment order. Paragraph. In response to the notice issued by the court, a reply has been filed by the Income Tax Officer Ward 1(1) Cuttack on the aspect of service of notices through email. It is asserted that these were sent to the assessee at its registered email address, open quotation, i.e. mmconsultancy@yahoo.com, unquote. As regards the non-passing of a draft order under section 144 capital B of the Act, it is simply contended that the said provision has been adhered to. By issuing a show cause notice to the SSC by email on 23rd September 2021. Paragraph. This court has heard the submissions of Mr. R. P. Kerr, learned counsel for the petitioner, and Mr. Chimanka, learned standing counsel for the department. It is plain from a reading of the counter affidavit of the department that the notices were sent to the wrong email address. The portal of the department itself reveals the email address of the petitioner to be mmeconsult@yahoo.com, whereas copies of the emails as sent to the petitioner, forming part of the counter affidavit, show that they were sent to the address single quotes mmecconsultancy@yahoo.com, unquote. Although a copy appears to have been sent to single quotes mmeconsult@yahoo.com, unquote, as pointed out by Mr. Kara, that emails of that sort, emails that are single quote CC, unquote, invariably end up in the spam mail and are not received in the inbox. Full stop. Therefore, there is no difficulty in the court coming to the conclusion that the emails addressed to the petitioner by the department were sent to the wrong email ID and therefore not received by the petitioner. Paragraph. As regards the mandatory requirement of a draft assessment order under section 144 capital B of the IT Act, this court, in its order dated 1st October 2021, in Writ Petition Civil 29279 2021, bracket Sribasta Kumar Swine versus Union of India, bracket as following the decisions of the Delhi High Court as well as this court. In Orissa, Steve Dose Limited was the Union of India, bracket, decision dated 8 July 2021. In writ petition civil 19402 of 2021. Invalidated assessment orders issued by the NFSC that were passed without complying with the mandatory requirement of section 144 capital B of the Act. Correct. Consequently, for both the above reasons, the impugned assessment order is held to be unsustainable in law and is hereby set aside. Nevertheless, the department is granted liberty to pass a fresh assessment order for the AOA in question after complying with the requirement of the law by giving the petitioner a personal hearing at a date and time which will be communicated to the petitioner sufficiently in advance. Full stop. The petitioner will cooperate in the fresh assessment proceedings and furnish all the documents and information available with it relevant to the proceedings. Also, the petitioner also permitted to urge before the in the fresh assessment proceedings all its contentions, including one of the contentions raised in the present petition, that proceedings pursuant to an order passed by the PCIT under section 263 of the Act should have been in conformity to section 150 of the Act.
But not 143.
And not section 143 bracket 3 thereof. Full stop. The petition is disposed of in the above.
The demand and penalty notices is also
called. The consequent demand
and penalty
notices are also hereby quashed.
May I humbly pray, Lord, let them serve a draft assessment order so that I can file my
in
reply.
Compliance with law. They'll proceed only in compliance. Right.
Greatly obliged.
Right.
Supplementary list item number 38. My lord, in item number 38, many lawyers are there for the petitioners. That is that commercial court matter.
Correct. Arbitration and commercial.
I will only take 1 week time because I have already made it ready, the response affidavit. Any date next week or?
It's already delayed, he was saying.
My lords, I'll just apprise, my lords. The problem is that all this while the court is now almost virtually defunct because of these cases.
No, only in matters where Lordship has interfered, they are not doing passing any orders. No. But other matters, they are continuing. Because
then let it be clarified that other matters, they will continue and these objections, because every other case.
My lords, my difficulty is I am opposite party in 2 of the cases. They are pressing for interim orders to be passed there. Now, once in a section 9 matter, my lords, if an injunction, if an interim order is passed, I do not have a remedy of appeal also because no appellate EA has not been notified. And that is why it is all the more important that either the proceedings be stayed fully or your lordship may take it up because it is pure question.
Yes, my lords may take it up. Hear me.
No counter is warranted in this case. My lords, your lordship can straightway.
It's purely the provisions.
And
the judgments, nothing else.
We are ready to assist your lordship.
Yes, my lords.
Matter today.
I am ready with the counter. Only it is to be finally vetted. Next week, any date, Wednesday, your lordship may fix. I will file the counter. That is Wednesday.
If the Council for the State would agree, my lords, let us just submit the provisions of the Act, because prima facie what has been done, there is no infirmity in it, my lords. And the Madhya Pradesh judgment, which they are relying, that doesn't take note of earlier Madhya Pradesh judgment. So
as petitioners, let us
we are
put our case
petitioners.
thereafter. You can put your points across. If your
20,
lordships
23rd at 2 p.m. your lordship.
I can start off.
23rd at 2 p.m.
begin, my lords, because
we will file the response affidavit on Monday. Your lordship may, or Tuesday, 23rd at 2 p.m. Everybody will.
What is 23rd March?
Because if the counter is filed, then again the rejoinder would be warranted. It
No,
would
no,
be
no.
again
Counter will be very
No, no,
short.
I'll
Counter
make it
only.
clear that no further adjournment.
No rejoinder.
No rejoinder is will be.
In that case, let him give us an advance copy.
Correct.
Yes, we'll give. By Tuesday, we are giving.
Mr. D.K. Mantri, learned AG, assures the court that on 17th or 18th, when will you file it?
My lord.
When will you file it? 18th?
22nd, Tuesday.
You'll file your affidavit on 22nd?
Yes, my lord.
You said Monday, I thought 21st.
Yes, ma'am.
21st.
You file it on Monday, 21st? That on Monday,
Yes, ma'am.
21st March 2022, he'll file his affidavit with an advance copy to counsel for the other parties. Full stop. It is made clear that rejoinder, if any, be filed before the next date. There will be no further adjournments on this score. List on 23rd March at 2 p.m. Interim orders to continue.
May I just submit one thing, subject to what my friends say, my lords? This batch is pending here. This shouldn't affect other cases. Let that be clarified.
That is
Because
necessary, my lords.
they have not come. So that means the court is virtually blocked. They have not come before this court. But every other case, it is said that the court doesn't have jurisdiction.
These are stay orders.
It's
case
open.
specific.
Yes, but then they raise this objection in every other case. So let them come up. Matters before this court, stay order is there. I'm not saying anything.
Will happen in 1 week.
My lord, let this commercial court states hand for 1 week. The matter can
No. Those matters are not here. In every case, they are objecting to the jurisdiction of the court. And prima facie, my lords, on the face of the act, that is the court which is assigned these matters. I have given my counter, my convenience note.
Anyway, 1 week, it's just 1 week away.
1 week.
All right.
Grateful. Supplementary list for hearing item 39.
Katke, are you there?
Yes, boss, I am there. Fine.
What's the position here, sir?
Here 3 eyewitnesses are there, boss. Schedule 2, 3, and 4.
Item number 39, my lord. I have gone to the records one. So, Lordship, kindly give me 1 week time because there is nothing in this appeal. I will find out, my lord, whether there is anything, my lord.
Or we can just give you time to file a written note.
Yes.
We'll reserve orders and you file a written note of submissions. That may be better. We'll give you a week's time for that.
1 week, my
And
lord.
my friend has understood that there is nothing in the matter. My friend has understood that there is nothing in the matter.
No. You say orders reserved. The counsel for the parties are permitted to file their respective written notes of submissions within a week. All right.
Supplementary list item 40.
That's item 40. May I be permitted to appear to virtual mode?
Yes.
This is here. Union of India is the writ petition before Lordship. And today I have received the file. This short point.
Your Lordship, pardon to interrupt Your Lordship. This is a party, but the Wakalatnama is in transit, Your Lordship. I have not yet received the Wakalatnama. The brief was transferred to me yesterday, but the Wakalatnama is in transit.
You're for the opposite party?
Yes, Your Lordship.
What is there in the matter? What is it about?
The matter is about the opposite party, the Railway Recruitment Board, filled up his forms, appeared in the main examination, written test, got selected in the written test. However, during that time, the notification for viable test was given in a newspaper, employment news, as well as notice board of RRB. But on 28th, the news was, the notification on the Dharitri was given, but on 29th, there was super cyclone. So for that, however, he didn't appear for the viable test. Out of 10 candidates, there were 830 candidates appear. However, taking resort to the viable, this super cyclone, he didn't appear and subsequently challenged that because of super cyclone, I can appear. So I may be permitted to appear before the viable test. The Honorable, the learned tribunal
Mr.
note of it.
Tibrewal.
Lordship.
No, the counsel for the opposite party. What's his name? Mr. Tibrewal?
Yes, Your Lordship, yes.
So your client today is about 47 years old.
Yes, Your Lordship.
So he must have appeared in subsequent selections, I'm sure.
That I have to take instructions, Your Lordship. Actually,
No, at the age of 47, he wants to be an engine driver. Train assistant driver.
Train assistant driver, Your Lordship.
He's still interested in being that.
That is what I have been told, Your Lordship. I have to take instructions.
See, normally these people keep trying. He was just 25 when he made this attempt. I'm sure he must have appeared in subsequent selections. Just find out. Counsel for the opposite party. It's time for instructions whether the opposite party is still interested in pursuing the litigation. Just on 5th April, sir.
Obliged.
Supplementary list passed over matter. Item number 13. Supplementary list item number 13.
Somebody took a pass over. Somebody sought to pass over it. Not in this, is it? None appears despite a passover. Dismissed for non-prosecution.
Supplementary list item number 23.
Sorry, my lord, I could not be there at the time.
No problem.
Lord, the short point involved here in this matter is there has been an order of recovery to the extent of 3 lakh some odd rupees against the petitioner, Deputy Superintendent of Orissa State Warehousing Corporation, without following a proceeding, without any inquiry, without any natural justice, without any order of recovery by a properly constituted proceeding. That would be the short point for consideration. Now, the petitioner was the Superintendent of Orissa State
Warehousing Corporation. Was it stayed by this court?
It was stayed because if Lordship would kindly see, there has been earlier identical matters came before this.
And now he's retired.
Now he's retired, and all his retired benefits are also held up. They are not paying. Kindly see, my lord, identical matters came before your lordships earlier, this honorable court earlier. This honorable court has set aside the recovery order directing them to initiate a proceeding, hold an inquiry. It's a major punishment. It's a major punishment. Without a proceeding, 2009 Supreme Court is also there. They cannot pass an order of punishment.
Correct. What do you say?
May I please, Lordship? I am appearing for the respondent number 3, 4, and 6, your Lordship, submitting my counter by page 2, para 7, and submitting that since the Food Corporation of India (FCI) recovered the same amount of rupees 3,69,608 towards transit loss of pertaining to the period of incumbency of a petitioner in Bolangiri warehouse from the bills of the OSWC, it was necessitated to make goods the loss of by recovering from him. In this regard, memo number 76/2008 of the Zonal Manager OSWC Titilagar is enclosed here with annexure 1, your lordships, page 5, your lordships.
No, this is not a memo addressed to him, sir.
Yes, the counter para 8, your lordships.
No, this is just a demand saying please deposit. This is not preceded by an inquiry. What he's trying to say is this has to be preceded by an inquiry.
I submitting your lordship.
You have to issue a show cause notice. He has to be given asked an explanation, and then you proceed with recovery after an inquiry.
As for my counter, I am submitting these 2 documents, your lordship, on annexure 1 and
there is no answer to that in the counter.
In my counter, your lordships.
And
page 5 and page.
Peculiarly, if your lordship could see, FCI says there is 1.91% transit loss. FCI against the warehousing corporation says 1.91% transit loss. Now they are passing an order that short loading at the time of loading.
Oh, not
that's again incongruous. If your lordship permits, I can show those incongruities available in the order sheet.
But anyway, no notice was issued to you.
Right.
All right.
And one just request to your lordship. No?
Yes.
That the petitioner in the meantime has retired. They have held up all the retirement dues on this short 3 lakh some odd rupees.
Right.
That your lordship may kindly.
All right. to say the challenge in the present petition by a former employee of the Orissa State Warehousing Corporation, Titlagarh, bracket, opposite parties 3, 4, and 6, bracket. Is to an order dated
Annex 10. 6/3/2009. 6/3/2009. Annex 8. Or 10. 10. Annex 12. I'm so sorry. Annex 12. But I'm sorry. Annex 12. 8/6/2010. 12. I'm so sorry.
Is to an order dated 18 June 2010, issued by the OSWC, informing the petitioner that orders had been passed by the competent authority to recover a sum of rupees 369,08 from the petitioner, open quotation, towards the transit loss value pertaining to Bolangir warehouse, unquote. And accordingly, a sum of rupees 3,850 had been deducted from the monthly salary of the petitioner for May 2010. So the balance amount was to be recovered in terms of a separate memorandum dated 3rd June 2010. Paragraph. While directing notice to issue the present petition on 21st September 2010, the court directed the opposite parties not to effect any recoveries pursuant to the aforementioned letters dated 18 June 20, orders dated 18 June 2010 and 3rd June 2010, both of which are challenged in the present petition. Paragraph. The short ground on which the impugned orders have been challenged is that they are violative of the principles of natural justice. So the orders tantamount to a punishment inflicted on the petitioner without instituting any inquiry and without even a show cause notice. Paragraph. In the counter affidavit filed on behalf of the OSWC, it is stated that the Assistant General Manager bracket Vigilance had addressed a letter to the area manager of the Food Corporation of India at Titlagarh. Sorry, the Assistant General Manager Vigilance of the Food Corporation of India bracket FCI had addressed a letter to its area manager at Titlagarh regarding higher transit losses in respect of 32 wagons loaded from OSWC Bolangir. Enclosed with the counter affidavit is a letter dated. No, is a letter addressed by the zonal manager, Titlagarh zone, to the superintendent OSWC Bolangir. stating that the transit loss, in view of the transit loss, FCI deducted 414,724 from the OSWC's storage charge bills towards cost of excess transit loss beyond 0.360%. Full stop. Consequently, the superintendent OSWC was asked to deposit the above amount in the OSWC's account immediately. Paragraph. The counter-affidavit is totally silent on whether any SCN was issued to the petitioner at all prior to effecting recoveries from his monthly salary and prior to issuing the order directing the aforementioned entire sum of rupees 414,724 to be recovered from him. Full stop. In other words, there is no denial of the fact that prior to issuing the impugned orders, no notice was in fact issued to the petitioner. Consequently, the court has no difficulty in coming to the conclusion that the impugned orders are in violation of the principles of natural justice and are therefore unsustainable in law.
2 minutes I'll disturb you. Is a usual practice in the service rule after retirement is bound to give this losses, my lord.
Only if there has been some
After the
notice or
retirement
inquiry,
also,
sir.
if the storage loss is found.
Once there is an inquiry and once you establish that he's the
There is
person.
an inquiry. There is an inquiry, my lord.
Where?
Is vigilance kindly come to the annexure to my counter?
Is it an
Vigilance-
inquiry after notice to him, sir?
No, my lord, this inquiry.
No. Just follow the question, sir.
Yes.
Maybe you did not follow the question. Was there an inquiry preceded by a show cause notice to him?
No.
Getting a reply from him and then concluding an inquiry and giving an inquiry report. That's the question.
No, that is not. That is not.
That's why it's violation of natural justice.
But in this case, there is a vigilance inquiry where there is
Sir,
a
that is
report.
all behind his back, sir. You have to, in fact, give him copy of that vigilance inquiry report and ask him.
No, it is there with him. It is there with him.
Not, sir.
It is there with him.
Sir, you are missing the point altogether. It is now there with him because it has been enclosed to your counter affidavit. Correct?
Yes.
Prior
to that, it is given to him also.
Sir, not asking for his explanation. Only the conclusion is given to him, sir. Saying that we have decided to recover 4 lakhs from your salary.
No, not at all, man. Not at all.
Sir, show me any one show cause notice you issued to him.
No.
Then what is this? What you are not following the point,
No,
sir.
I have followed, my lord. This is a usual practice.
That's not.
There is a
Then the
rule-
usual practice is wrong,
There is a
sir.
rule that if there is a loss, storage losses for any ground, this is a case of misapprehension, my lord.
All right. Sir, I am dictating my order. You can comment on it at leisure, sir. All right.
Lord, one just request, my lord. In place of 4 lakhs 14724, that should be 3,69,607. That's what is the order for recovery against me.
I see. All right. I'll correct that. Paragraph. Mr. P.K. Rathal, learned counsel to the petitioner, points out that on account of pendency of the present petition and the recovery proceedings, none of the retirement dues have been paid to the petitioner, despite his having superannuated on attaining the age of 60 years. Also, the court directs that the retirement dues should no longer be withheld from the petitioner. Full stop. It is clarified that the present order will not prevent the OSWC from proceeding in accordance with law.
Yes.
By conducting a proper inquiry after show cause notice to the petitioner for recovery of the aforementioned sum. The petition is disposed of in the above terms.
Supplementary pastoral matter item number 32.
May I please, my lord? May I please, my lord? I am in this, my lord. My lord, in this case, my lord, petitioner paid, my lord, for promotion to Sirastadar, my lord, with effect from 1/9/2016. Here in this case, my lord, in the year 2016, The petitioner is second senior most grade 1 BC, bench clerk, my lord. There was a selection committee in the first part of the 2016, my lord, in which the petitioner who is the second senior most and one KC Guru who is the senior most were considered for promotion to Sirasdar, my lord. And pursuant to that DPC, my lord, KC Guru was promoted on 1/7/2016, my lord, and retired on the very same month, my lord. Thereafter, my lord, the petitioner became the senior most Sirasdar under the judgeship of the Khordha, my lord. And he had only 4 months left for his superannuation, my lord. During that period, my lord, the petitioner approached several times for consideration of the promotion to the post of Sirasdar. But he was not promoted and allowed him to retire, my lord. Just after his retirement, they convened a DPC and promoted his junior to the post of Sirasdar, my lord. My lord, under Annex 5, 6, and 7, my lord, that is annexed to my additional affidavit, wherein the opposite party number 3, my lord, granted promotion to the grade 1 BC to the post of Sirasdar just the very month of his retirement, and after 1 month being a Sirasdar, they were retired, my lord. So, my lord, during that period, the petitioner legitimately expected that he will get promotion to the post of Sirasdar and will retire, by which he can able to get some retiral benefits, my lord. But in the instant case, he was denied promotion to the Sirasdar and allowed to retire as a grade 1 BC 1, my lord. And immediately after his retirement, his junior got promotion.
That's the only point, sir. So let us hear Mr. Mudli. All right.
Your Lordship, may submit. The claim of the petitioner for promotion to the post of Sirasdar is contrary to the rule. May I place the rule that is Rule 11. Your Lordship, that rule will Your Lordship will get at page 24 of the additional affidavit of the petitioner. Running page 24 of the additional affidavit. May I please? Top 11, promotion to higher post.
Right.
Promotion to the higher post shall be subject to passing of the departmental examination and shall be based on merit and suitability in all respects with due regard to seniority. Now, these are two important things. One, he has to pass the departmental examination, and the consideration will be merit cum suitability with due regard to seniority. It's not the seniority alone. Now, C relates to promotion to the post of Sirasdar of the district court shall be made from amongst the bench clerks grade 1. So a bench clerk, in order to get the promotion to the Sirasdar, he has to pass the departmental examination, and thereafter he will be considered on the basis of merit cum suitability with due regard to seniority. Now we have filed the counter affidavit indicating at paragraph 11 that the petitioner was never adjudged as eligible and suitable for promotion to the post of Sirasdar. Paragraph 11, internal page 5 of my counter.
Yes.
Fifth line from top, paragraph 11. But in the instant case, the petitioner was not adjudged by any committee or authority to be eligible and suitable to get the promotion. Now, Your Lordship, can see he is claiming only on the basis of seniority. Your Lordship, can turn to page 5 of the writ petition, paragraph 8.
But he's saying that all his one guru got appointed as Sirasdar only for a month. Usually, he says closer to the point of retirement, a DPC is held, they're given that promotion, then they retire. So they retire at the higher post. So he says the minute his retirement happened,
yes,
within a week thereafter, a DPC was held, his juniors got promoted.
Why it was not held, that there is no explanation either by the petitioner or by the...
No, petitioner doesn't know. Why will he give an explanation?
And Your Lordship, can see paragraph 8 of my counter. How many adverse remarks against the petitioner?
There are 8.
Yes, page 3 of my counter. May I place me?
Yes.
That in reply to the averments made in paragraph 4 of the writ application, it is humbly submitted that the contents of the petitioner, while functioning as grade 1 bench clerk, he does not have any adverse remarks, is correct. But it is a fact that the petitioner was placed under suspension for the period from 1/9/1980 to 31/10/1983. And the said period of suspension was treated as period of duty by Puri District Court order number so and so dated 18/4/1985. One increment in the present scale of the petitioner was stopped without cumulative effect in DP number so and so. And his period of unauthorized absence on 2/5/84, 10/5/84, 21/6/84, 23/6/84, 6/7/84, 7/7/84, 12/7/84, and 16/7/84 to 27/84 was treated as leave without pay. During the period 1983 to 1984, the petitioner was not sincere and his work was not satisfactory. During the period from 1986 to 87, he was not sincere and slack, does not take responsibility. He was very much slow in his work and works whimsically during the period from 1989 to 1990, though he was well behaved, sincere, but not hardworking.
Para 7, my lord, the counter para 7.
Yes.
May I place, my lord, para 7 of the counter, my lord? In reply to averments made in para 3 of the writ petition, it is humbly submitted that the Jasi of Khordha was established in the month of May 97, being separated from the Jasi of Puri. The claim of the petitioner, supported by the affidavit that he was deployed in the Jasi of Khordha on 25/8/1993, on the eve of separation of Khordha Jasi from the Jasi of Puri, is not correct. It is a fact that the petitioner was promoted to the cadre of senior clerk, grade 1 bench clerk, grade 1 bench clerk on 1/9/98, 12/11/2003, 1/5/2010, my lord. My lord, when he was promoted, got 3 promotions thereafter, the remarks which of the year 84, my lord, lost his force, my lord. It cannot be utilized at the distance of the time.
Right. The only point is, why was a DPC not held? That's the only point.
Yes.
My lord, just on the very same year, my lord, DPC was held, and I was considered with the KC Guru, my lord. Since the KC Guru was senior most person, he was promoted and joined on 1/8/1916, my lord, and retired on 31st August 16, my lord. So I legitimately expected that since the DPC of the same year, I may be promoted to the post of Sirastadar after his retirement, my lord.
In the holding of DPC after retirement of KC Guru until the month of January 2017, that specific instruction I have to get whether that was held or not, and if it was held, whether the case of the petitioner was also considered or not.
Well, after my retirement, my lord, they considered that was admitted by in the counter, my lord. And one Shetty got promotion after my retirement.
When did you retire, sir?
Retired on 31st January 2017, my lord.
So his point was KC Guru retired when?
31st August 2016.
He says for 2016, if you held a DPC and put KC Guru as 1 and him as 2, you need to hold another DPC for the same year.
No, my lord, that is my, from that DPC I could have promoted, my lord.
There is only one post of Saristadar.
No. So when KC Guru retired,
yes,
his post fell vacant.
Yes. That instruction I have to take whether after retirement and until the petitioner also retired, whether there was any DPC for promotion to the post of Saristadar.
Do you have to have, I think the point he's making is for 2016.
Yes.
One DPC is held in which KC Guru is found eligible for promotion.
2016 itself.
That's right. Once he retires in August 2016 itself, you need to have one more DPC.
Yes.
Why should you have one more DPC is the question. One of the issues raised by counsel the petitioner is that in the year 2016, a DPC was held for promotion to the post of Sheristadar from the post of Senior Bench Clerk 1. in the district judgeship of Khurda, in which one Mr. K.C. Guru was found eligible for promotion and was in fact so promoted. The petitioner's case was also considered in the same DPC. And according to the petitioner, he was the next eligible person for such promotion. Stop. K.C. Guru retired on 31st August 2016, and therefore the post of Saristadar again fell vacant. Stop. According to the petitioner, there was no need to have any further DPC in 2016, and the petitioner should have been promoted as Saristadar on the retirement of K.C. Guru. Paragraph Mr. Mudali states that he needs to take instructions on the above submission. At his request list on 25th April.
Obliged.
All right.
Obliged.